न्याय का सबके लिए, आकाश न्याय का सबके लिए, उल्लास न्याय का सबके लिए, विश्वास न्याय का सबके लिए। अपने इस हिंदुस्तान पर हक हमारा भी तो है, इंसाफ के इस आशिया पर हक हमारा भी तो है। एक मुट्ठी आसमां पर हक हमारा भी तो है, एक मुट्ठी आसमां पर हक हमारा भी तो है।
ये ना सोचो दर्द हमारा कहीं सुना न जाएगा, अब न्यायालय खुद चलकर चौपालों तक आएगा।
लाचारों को न्याय मिलेगा, दुखियारों को न्याय मिलेगा, कमजोरों को न्याय मिलेगा, मजलूमों को न्याय मिलेगा। अपने इस हिंदुस्तान पर हक हमारा भी तो है, उम्मीदों के इस गुलसितां पर हक हमारा भी तो है। एक मुट्ठी आसमां पर हक हमारा भी तो है, एक मुट्ठी आसमां पर हक हमारा भी तो है।
गरीब और कमजोरों को मुफ्त एवं सक्षम कानूनी सहायता के लिए प्रतिबद्ध विधिक सेवा प्राधिकरण नालसा, न्याय सबके लिए।
एहसास न्याय का सबके लिए, आकाश न्याय का सबके लिए, उल्लास न्याय का सबके लिए, विश्वास न्याय का सबके लिए। अपने इस हिंदुस्तान पर हक हमारा भी तो है, इंसाफ के इस आशिया पर हक हमारा भी तो है। एक मुट्ठी आसमां पर हक हमारा भी तो है, एक मुट्ठी आसमां पर हक हमारा भी तो है।
ये ना सोचो दर्द हमारा कहीं सुना न जाएगा, अब न्यायालय खुद चलकर चौपालों तक आएगा।
लाचारों को न्याय मिलेगा, दुखियारों को न्याय मिलेगा, कमजोरों को न्याय मिलेगा, मजलूमों को न्याय मिलेगा। अपने इस हिंदुस्तान पर हक हमारा भी तो है, गुलसितां पर हक हमारा भी तो है। एक मुट्ठी आसमां पर हक हमारा भी तो है। एक मुट्ठी आसमां पर हक हमारा भी तो है।
गरीब और कमजोरों को मुफ्त एवं सक्षम कानूनी सहायता के लिए प्रतिबद्ध विधिक सेवा प्राधिकरण नालसा, न्याय सबके लिए।
एहसास न्याय का सबके लिए, आकाश न्याय का सबके लिए, उल्लास न्याय का सबके लिए, विश्वास न्याय का सबके लिए। अपने इस हिंदोस्तां पर हक हमारा भी तो है। इंसाफ के इस आशिया पर हक हमारा भी तो है। एक मुट्ठी आसमां पर हक हमारा भी तो है। एक मुट्ठी आसमां पर हक हमारा भी तो है।
ये ना सोचो दर्द हमारा कहीं सुना न जाएगा। अब न्यायालय खुद चलकर चौपालों तक आएगा।
लाचारों को न्याय मिलेगा, दुखियारों को न्याय मिलेगा, कमजोरों को न्याय मिलेगा, मजलूमों को न्याय मिलेगा। अपने इस हिंदोस्तां पर हक हमारा भी तो है। उम्मीदों के इस गुलसितां पर हक हमारा भी तो है। एक मुट्ठी आसमां पर हक हमारा भी तो है। एक मुट्ठी आसमां पर हक हमारा भी तो है।
गरीब और कमजोरों को मुफ्त एवं सक्षम कानूनी सहायता के लिए प्रतिबद्ध विधिक सेवा प्राधिकरण नालसा, न्याय सबके लिए।
एहसास न्याय का सबके लिए, आकाश न्याय का सबके लिए, उल्लास न्याय का सबके लिए, विश्वास न्याय का सबके लिए। अपने इस हिंदोस्तां पर हक हमारा भी तो है। इंसाफ के इस आशिया पर हक हमारा भी तो है। एक मुट्ठी आसमां पर हक हमारा भी
ना सोचो दर्द हमारा कहीं सुना न जाएगा, अब न्यायालय खुद चलकर चौपालों तक आएगा।
लाचारों को न्याय मिलेगा, दुखियारों को न्याय मिलेगा, कमजोरों को न्याय मिलेगा, मजलूमों को न्याय मिलेगा। अपने इस हिंदुस्तान पर हक हमारा भी तो है, उम्मीदों के इस गुलसितां पर हक हमारा भी तो है। एक मुट्ठी आसमां पर हक हमारा भी तो है, एक मुट्ठी आसमां पर हक हमारा भी तो है।
गरीब और कमजोरों को मुफ्त एवं सक्षम कानूनी सहायता के लिए प्रतिबद्ध विधिक सेवा प्राधिकरण नालसा, न्याय सबके लिए।
एहसास न्याय का सबके लिए, आकाश न्याय का सबके लिए, उल्लास न्याय का सबके लिए, विश्वास न्याय का सबके लिए। अपने इस हिंदुस्तान पर हक हमारा भी तो है, इंसाफ के इस आशिया पर हक हमारा भी तो है। एक मुट्ठी आसमां पर हक हमारा भी तो है, एक मुट्ठी आसमां पर हक हमारा भी तो है।
ये ना सोचो दर्द हमारा कहीं सुना न जाएगा, अब न्यायालय खुद चलकर चौपालों तक आएगा।
लाचारों को न्याय मिलेगा, दुखियारों को न्याय मिलेगा, कमजोरों को न्याय मिलेगा, मजलूमों को न्याय मिलेगा। अपने इस हिंदुस्तान पर हक हमारा भी तो है, उम्मीदों के इस गुलसितां पर हक हमारा भी तो है। एक मुट्ठी आसमां पर हक हमारा भी तो है, एक मुट्ठी आसमां पर हक हमारा भी तो है।
गरीब और कमजोरों को मुफ्त एवं सक्षम कानूनी सहायता के लिए प्रतिबद्ध विधिक सेवा प्राधिकरण नालसा, न्याय सबके लिए।
एहसास न्याय का सबके लिए, आकाश न्याय का सबके लिए, उल्लास न्याय का सबके लिए, विश्वास न्याय का सबके लिए। अपने इस हिंदुस्तान पर हक हमारा भी तो है, इंसाफ के इस आशिया पर हक हमारा भी तो है। एक मुट्ठी आसमां पर हक हमारा भी तो है, एक मुट्ठी आसमां पर हक हमारा भी तो है।
ये ना सोचो दर्द हमारा कहीं सुना न जाएगा, अब न्यायालय खुद चलकर चौपालों तक आएगा।
लाचारों को न्याय मिलेगा, दुखियारों को न्याय मिलेगा, कमजोरों को न्याय मिलेगा, मजलूमों को न्याय मिलेगा। अपने इस हिंदुस्तान पर हक हमारा भी तो है, उम्मीदों के इस गुलसितां पर हक हमारा भी तो है। एक मुट्ठी पर हक हमारा भी तो है, एक मुट्ठी आसमां पर हक हमारा भी तो है।
गरीब और कमजोरों को मुफ्त एवं सक्षम कानूनी सहायता के लिए प्रतिबद्ध विधिक सेवा प्राधिकरण नालसा, न्याय सबके लिए।
एहसास न्याय का सबके लिए, आकाश न्याय का सबके लिए, उल्लास न्याय का सबके लिए, विश्वास न्याय का सबके लिए। अपने इस हिंदुस्तान पर हक हमारा भी तो है, इंसाफ के इस आशिया पर हक हमारा भी तो है। एक मुट्ठी आसमां पर हक हमारा भी तो है, एक मुट्ठी आसमां पर हक हमारा भी तो है।
ये ना सोचो दर्द हमारा कहीं सुना न जाएगा, अब न्यायालय खुद चलकर चौपालों तक आएगा।
लाचारों को न्याय मिलेगा, दुखियारों को न्याय मिलेगा, कमजोरों को न्याय मिलेगा, मजलूमों को न्याय मिलेगा। अपने इस हिंद दोस्तों पर हक हमारा भी तो है, उम्मीदों के इस गुलसितां पर हक हमारा भी तो है। एक मुट्ठी आसमां पर हक हमारा भी तो है, एक मुट्ठी आसमां पर हक हमारा भी तो है।
गरीब और कमजोरों को मुफ्त एवं सक्षम कानूनी सहायता के लिए प्रतिबद्ध विधिक सेवा प्राधिकरण नालसा, न्याय सबके लिए।
On behalf of the Assam State Legal Services Authority and the Guwahati High Court, the High Court of Assam, Nagaland, Mizoram and Arunachal Pradesh, I would like to extend a warm welcome to you all to the 4th technical session of the National Legal Services Authority East Zone Regional Conference of 7 northeastern states and Sikkim, Bihar, West Bengal, Jharkhand and Odisha. The topic of this session would be problems faced by the tea garden population and challenges to eradicate those problems. The tea garden population continues to face a host of challenges, including low wages, inadequate housing, limited access to health care and education, and poor sanitation facilities. These issues contribute to a cycle of poverty, malnutrition, and social vulnerability, including high dropout rates and substance abuse. We are hopeful that this conference will provide valuable insights and practical inputs to help formulate effective strategies and interventions aimed at improving the living standards and overall well-being of tea garden workers and their families. Through this session, we look forward to receiving valuable insights and recommendations for upliftment of this underprivileged section. Ladies and gentlemen, to delve deeper on the subject, we are honored to have with us Honorable Mr. Justice Prashant Kumar Mishra, Judge, Supreme Court of India, who will chair this session. I would request you, sir, to kindly come forward and take your seat on the dais. He is being escorted by Srimati Mallika Datta, District and Session Judge, cum Chairman, DLSA, Nalbari. Honorable Mr. Justice Prashant Kumar Mishra was appointed as a judge of the Calcutta High Court in 2011 and acting Chief Justice in 2025 and subsequently as Chief Justice of the Meghalaya High Court. Our keynote speakers are Mr. Owen Chapa, Director, Legal Cell for Human Rights, to be escorted to the dais by Shri Abhijit Hoikia, Secretary, DLSA, Dibrugarh. Mr. Owen Chapa is an advocate at the Guwahati High Court, a visiting faculty at Marquette University, USA. He is pursuing his PhD in law from Assam University. With vast experience in human rights, child rights, and legal empowerment in tea garden communities, he has presented papers on law, gender, and social justice across India. Our next speaker is Dr. Ravi Kota, Honorable Chief Secretary, Government of Assam, to be escorted to the dais by Shri Rajesh Boro, Secretary, DLSA, Karbi Anglong. Dr. Ravi Kota, an IAS officer and PhD in agronomy, has vast administrative experience across local, state, national, and international levels. As Principal Finance Secretary, Assam, he led key fiscal reforms, including GST implementation, demonetization response, and state budget planning. Renowned for his expertise in public finance and development policy, he has also played a crucial role in mobilizing private investments and promoting financial inclusion. Well, we indeed have a great set of panelists to do a deep dive on the topic. Now, we would like to felicitate our esteemed guests on the dais, starting with Honorable Mr. Justice Prashant Kumar Mishra, Judge, Supreme Court of India. I'd request Shri Abhijit Bhattacharya, District and Session Judge cum Chairman DLSA, Hojai, to kindly do the honors. Thank you. May I now request Mrs. J. Dr. Chaudhary, Member Secretary, Tripura, to kindly felicitate Honorable Mr. Justice Shoman Sen, Chief Justice, High Court of Meghalaya. Thank you. We would now felicitate Mr. Owen Chapa, Director, Legal Cell for Human Rights. I would request Shri Debashish Kashyap, Joint Registrar, PM and P, cum CPC, Honorable Guwahati High Court, to kindly do the honors. Thank you. May I now request Shri Debashish Bhattacharya, Member Secretary, Assam State Legal Services Authority, to kindly felicitate Dr. Ravi Kota, Honorable Chief Secretary, Government of Assam. Thank you. I'd now hand over the session to Honorable Mr. Justice Prashant Kumar Mishra, Judge, Supreme Court of India, the chair of this session, to kindly commence the proceedings. The session would be for 1 hour and 15 minutes, with the first hour dedicated for the discussion and the remaining 15 minutes for questions. On to you, sir.
My esteemed brother, Justice Bishnoi, Justice Owen Sen, Chief Justice of Meghalaya High Court, Mr. Owen Chapa, Director, Legal Cell for Human Rights, Mr. R. Kota, Chief Secretary of Assam, Mr. Sujay Paul, Chief Justice, Acting Chief Justice of Calcutta High Court, Mr. Sundar, Chief Justice of Meghalaya High Court, Manipur High Court, Mr. Tarlok Singh Chauhan, Chief Justice of Jharkhand High Court, Mr. Harish Tandon, Chief Justice of Odisha High Court, and Mr. Bajantri, Chief Justice of Patna High Court, and the Master of the Ceremony, Mr. Justice Asutosh, Chief Justice of Patna High Court. Other honorable judges sitting over here from different high courts. The officers of the Assam Legal Services Authority, members of the Registrar General and members of the Registry of the Assam High Court. It is really with profound gratitude and humility that I stand before you today for sharing with you the discussion on the problems faced by the tea garden population and challenges to eradicate those problems. I would like to congratulate the Assam State Legal Services Authority and NALSA for organizing this two-day conference on issues touching the core of human lives specific to the citizens of northeastern states. In NALSA, we have been focusing on the problems faced by the downtrodden and marginalized class of society. And the aim and object is to reach out to the poorest of the poor in our quest to provide them access to justice. Assam's tea industry is not just a cornerstone of the state's economy. It is a symbol of India's global identity. Behind every cup of tea that graces our homes and boardrooms lies the untold story of resilience, exploitation, and contribution of the 6.5 million strong tea tribe community, constituting 20% of Assam's population, yet among the most socio-economically vulnerable. The discovery of wild tea plants in Assam is credited to Scottish adventurer Robert Bruce, who in 1823 learned of the plant's medicinal use from the indigenous Singpho tribe. Following the Yandabu Treaty of 1826 and British expansion into northeast India, the foundation of Assam's formal tea industry was established. Around the same time, Sri Maniram Devan, a nobleman, freedom fighter, and visionary entrepreneur, also entered the tea trade, foreseeing its potential to transform Assam's economy and contribute to the global tea market. Historically, the tea gardens were born out of colonial interest and were integrated not just with water, but with sweat and sufferings of laborers. Migrants brought in from different lands, often kept addicted, disenfranchised, and voiceless under the British rule. The laborers, then referred derogatory colloquially, were referred as coolie. They were made to addict to opium by strategic design by the colonial masters. Under the influence of substance abuse, they remained largely oblivious to their basic rights to life of dignity and the correspondent legal rights. Post-independent, India promised dignity, justice, and equal opportunity to all its citizens. While there have been laudable efforts, be it the Assam government scheme through the Tea Tribes and Adivasi Welfare Department, national mission like Swachh Bharat Mission, Gramin, and the Jal Jeevan Mission, a partnership of UNICEF with civil society, yet the ground reality remains deeply concerning. I will highlight mainly the topics which are problematic and creating problem for all of us, not only for those tea garden laborers. There is persistent malnutrition and poor health, labor exploitation and rights violation, lack of quality education, alcoholism and substance abuse, housing and living conditions, lack of legal identity and tribal recognition, women and child vulnerability, land insecurity, and human trafficking. The most pressing issue is malnutrition, with over 60% of children underweight. The community also suffers from limited access to quality education, resulting in high school dropout rates and low literacy levels, especially among girls, housing shortages, poor sanitation, and inadequate access to clean drinking water further worsen their living conditions. Another critical issue, though with which NALSA is not concerned, is their status as scheduled tribe for which they are struggling. But that is the domain of the parliament and the legislature. A deeply rooted and often overlooked issue within tea tribe communities is the prevalence of alcoholism and substance abuse. Introduced during the colonial era as a means of control, alcohol dependence has persisted across generations and now poses a serious threat to individual health, family stability, and community welfare. The challenges are, despite various government schemes and interventions, the tea tribe communities continue to remain on the margins of development, requiring a holistic, rights-based, and inclusive approach for their upliftment. They are not just government failures, they are failure of justice. The tea tribe communities of Assam, who form the backbone of state's thriving tea industry, continue to face deep-rooted social, economic, and legal challenges, despite their historical and economic significance. While the issue affecting tea tribe communities are well documented, addressing them remains complex and multidimensional. Justice Sen would be showing you a graphic view of the entire problem and the steps which should be taken for alleviating them. Mr. Owen Chapa and Mr. R. Kota, who belong to this area, they will be focusing on their own field. One write-up has been given by Mr. Kota. And I think this technical session would pave the way for implementation of the welfare schemes. Because as we understand, the government frames many schemes for the tea tribes, but most of them remain unimplemented in its entirety. As we have seen yesterday, many legal aid clinics have been opened in tea gardens, and there is need of forming clusters of tea estates and provide them with legal aid clinics. Because the main problem is that unless they are aware of their rights and the government schemes which benefits them, they are not able to approach the concerned authority seeking remedies from the problems which they are facing. And this is the area in which the Assam Legal Services Authority have to work and work hard to uplift the tea garden workers, uplift their lifestyle, uplift their dignity, and to bring them in the mainstream so that they can compete in their life shoulder to shoulder with other citizens who stay in the urban part and the other plains of the Assam and the northeastern states. Thank you so much, Chief Justice Ashutosh Kumar ji and the Assam State Legal Services Authority for giving me this opportunity. I open the house for discussion. Thank you. I will now request Chief Justice Meghalaya High Court, Justice Owen Chapa, to address.
A very good morning to all of you. Honorable Mr. Justice Prashant Kumar Mishra, Judge, Supreme Court of India, and the chair for today's session, the honorable judges of the Supreme Court, the Chief Justice of the Guwahati High Court, Justice Ashutosh Kumar, the honorable Chief Justices and judges of different high courts, the distinguished speakers on the dais, ladies and gentlemen. I am overwhelmed, truly honored, and privileged to be here today and for the invitation extended to me. When I received a call from Justice Michael Zothan Kumar informing me that I will be co-chairing the session concerning the problems faced by the tea garden laborers, it immediately reminded me of a novel I read when I was in school, recommended by my father, Two Leaves and a Bud, by Mulk Raj Anand. This novel was set in the background of tea gardens in Assam during early 1940s, which portrayed the colonial exploitation of laborers in the ashram tea plantation. It is centered around a character called Gangu, a Punjabi peasant and his family who were lured to the plantation with false promises of a better life only to find themselves trapped in a brutal and oppressive system. It essentially raises issues regarding colonial and capitalist exploitation, the dehumanization of the working class, social and class conflict, injustice and failure of the legal system, human suffering and endurance, and a contrast between hope and reality. In the novel, we also find a character like Dr. John Taylor Harv, which illustrates the internal conflicts and moral struggles within the colonizing group. This character is important and relevant as even in the present scenario, we find there are few owners and managers of the tea gardens who are sympathetic to the cause of laborers but are unable to fulfill all the requirements due to financial stringency. The novel also highlights that when Gangu was murdered by an English officer, the subsequent trial results in officers' acquittal. It's just like injustice lords over justice, and the justice is loser by comparison to quote Plato's Republic. This poem of suffering had created a lasting impression on me. In my presentation, I would like to contrast the situation that prevailed prior to independence, post-independence, and the way forward. The position before the Plantations Labor Act of 1951 was that the plantation labor force was composed of migrant tribal and backward class workers who were contractually recruited from various Indian states and subjected to harsh treatment by colonial planters. These planters, aided by British laws and recruitment systems like Arkati, Sardars, and indentured labor, ensured an insufficient and isolated workforce that was housed on plantations without basic amenities. To depress wages, planters paid workers partly in ration supplies, the cost of which was deducted from their earnings, creating a cycle of debt and dependence that was intensified by the workers' isolation and lack of access to markets or the outside world. This isolation, combined with extremely low wages and coercive practices including debt bondage through Kanganis, corporal punishment, and withholding wages, prevented workers' organization and unionization, leading to the failure of early sporadic struggles for higher wages despite the extreme economic hardship faced by the laborers. The question arises whether after independence there has been any improvement in the living conditions of the workers and laborers working in the tea plantation industry. In my mind, the condition of the labor force as portrayed in the novel is still relevant today with some improvements due to social legislations and judicial interventions, as it focuses on the exploitation of the workers and social injustice, which is manifest when we consider the global labor markets. The marginalized workers are exploited to extract profit, and they become victims of oppression and often lack resources to fight for their economic and labor rights. After independence, we have a few legislations and certain labor welfare measures introduced. The Minimum Wage Committee for Plantations was established after the sector was included under the Minimum Wages Act of 1948. It was a tripartite body, meaning it considered of representatives from the government, employers, and workers' organization. This committee was instrumental in shaping early wage policy. Its key recommendations were later adopted by the Central Wage Board for the tea plantation industry, which was constituted in 1960 under the Plantations Labor Act of 1951. The evolutionary dynamics of tea plantation wages were guided by the principle that a fair wage should have a lower limit set by a worker's basic needs, that is the minimum wage, and an upper limit determined by the tea industry's financial capacity. Actual wages were intended to reflect factors like labor productivity, prevailing wage rates in similar industries, and the overall national economy. A key distinction was made regarding non-cash benefits. They were only to be counted towards the wage if they genuinely reduce a worker's living expenses. Ultimately, this framework, combined with government intervention and growing unionization, began to challenge the planters' long-standing practice of suppressing wages. This Act of 1951 was established as a comprehensive legal framework to ensure decent living conditions, fair wages, and social security for plantation workers by mandating provisions for housing, healthcare, limited working hours, and protection for women and children. However, a critical analysis reveals significant shortcomings, including its exclusion of small plantations with fewer than 15 workers and casual laborers, its failure to correct gender-based wage discrimination where female workers receive less than males for the same work, and its perpetuation of a daily wage system that denies payment for holidays. The Minimum Wages Act 1948 was enacted as a piece of social welfare legislation to secure a basic standard of living for workers engaged in scheduled employments. Its primary objectives are to prevent the exploitation of labor by ensuring that wages do not fall below a statutory minimum level. Although there are beneficial aspects like legal recognition of minimum wage and periodic revision mechanism, the Act's failure lies in poor implementation rather than intent. The application of the Act in the tea sector is undermined by fragmented wage fixation, wages below the subsistence level, weak enforcement, and the exclusion of social security, highlighting a systemic failure in both acts to fully protect workers due to instrumental exclusions, lack of a living wage approach, and the unresolved financial burden of social costs on planters that impedes grassroots implementations. Reforms such as a uniform national wage floor, living wage policy, integration with social security laws, and gender-sensitive measures are needed to ensure true dignity and justice for tea workers. Tea plantations in West Bengal operate in a feudal economic setup where wages have remained low despite collective bargaining since the 1970s. The tripartite negotiation between planters' unions and the government fails due to weak new unions, reluctant employers, and a passive state. As a result, low wage cycles persist and the collective bargaining mechanism remains ineffective. While interacting with the tea garden workers, their families, and all other stakeholders in a mega legal camp that we held on 20th September 2025, we identified few problems. The objective of the said program was to create awareness about legal rights, welfare schemes, and entitlements available to tea garden workers while also providing a platform for addressing the challenges faced by this community in their daily lives. It seems that most of them were unaware of the social welfare schemes, the relevant labor laws, and their statutory entitlements. Schooling severely suffers in the northern tea-bearing districts of West Bengal. Neither do we have a government schools within 1.6 kilometers radius with tea plantations as a foci, nor do we have schools run by the planters. Consequently, as we have seen, children of the migrant labor workforce are being deprived of their constitutional right to free education. In fact, there are several dropouts in schools. We have emphasized proper healthcare, nutrition, and education to the children. There are also other issues such as delayed or non-payment of wages, non-payment of PF contributions, occupational hazards, and access to social welfare schemes. The workers have voiced their concern relating to wages, social security benefits, workplace safety, and access to legal remedies. Now, I flag some of the issues in some detail. The first is with income insufficiency. Limited employment to only one family member in the tea gardens cause income insufficiency. Poor living conditions, large-scale migration, and disruption of the socio-economic balance. Then second is living conditions. Housing is severely substandard, with 80% of the residential quarters being dilapidated. There is a lack of maintenance, no repairing, poor sanitation, inaccessible pure drinking water, poor roads and drainage, and no land ownership rights. Then wages and benefits. Daily wages are low, between 240 and rupees 240 and 250, and not uniform. A significant problem is the exploitation by the middlemen, who siphon off up to 50% of the workers' provident fund and gratuity payments, leading to delays, uncertainty, and reduced income. Lack of occupational safety. Workers, especially women, face hazardous conditions, including exposure to pesticides without proper safety equipment. There's a critical lack of safety training, poor infrastructure, and weak enforcement of safety regulations. Healthcare facilities is also required to be addressed. Most plantations fail to provide the legally required medical facilities. There are no hospitals, a lack of emergency equipment, and a very high maternal mortality rate. In one of the districts we find is almost 48%, alongside reported cases of severe acute malnutrition. The tea gardens are not following Section 10, Subsection 1 of the Plantations Labor Act 1951, insofar as relates to extending medical facilities to the workers and their families. The health problems are widespread and severe, with an extremely high rate of anemia, which is about 87.9%, respiratory problems, which is 43.8%, had airway obstructions, and undernourishment, almost 36.1%, other common issues like skin disorders and musculoskeletal disorders. The presence of these health problems could be linked to long working hours outdoors, exposure to agricultural chemicals, or inadequate protective measures. Collectively, these statistics underscore the urgent need for targeted health interventions and improved working conditions to address the multitude of health challenges faced by the tea workers. Addiction is also a major problem, with 43% of the workers in Alipurduar addicted to substances, primarily tobacco and alcohol. There are various government schemes. Unfortunately, the workers are not aware of this. For example, the government housing initiatives like MGNREGS, Pradhan Mantri Awas Yojana, PMAY, and in state of West Bengal, there is Cha Sundari scheme. They aim to support the tea garden workers by providing employment during off-seasons and ensuring access to permanent housing with basic amenities for all, especially the poor and homeless. Tea plantation workers can seek remedies through statutory and administrative channels. In fact, we have opened clinics in almost all the tea gardens, and our TLSS secretaries are visiting the tea gardens every week. So we are providing the free legal aid, and with the support of the NGOs and civil society organizations. The remedies include enforcing minimum wage laws in line with MGNREGA, abolishing gender pay disparity, ensuring compliance with labor laws, PLA, and providing healthcare, housing, and education. Possible solutions are an emphasis on food security, skill development, sustainable practice, and strong collaboration among government, employers, and unions to improve workers' living standards. The condition of tea laborers in India reflects a paradox. India being the second largest producer and exporter of tea, and at the same time its tea garden laborers suffer from poverty and lack of social security. The plight of tea laborers in India is chronic and sensitive. These conditions demand multi-dimensional approach, focusing on long-term welfare to address marginalization. I may flag few. To start with, ensuring access to clean and safe water. Recent survey reports conducted by paralegal volunteers of districts such as Jalpaiguri reflected problems such as availability of water, land pattas not being allotted, long delays in payment of gratuity, lack of potable water has become a major challenge in tea estates, forcing the laborers to depend on unsafe sources. Installation of water filtration systems and rainwater harvesting can be considered as an immediate measure, while schemes such as National Rural Drinking Water Program must be effectively extended, along with periodical monitoring of water quality by district authorities. Then we need to strengthen the medical and healthcare facilities, to which I have just referred. Then legal recognition of plots, that is granting of land pattas and tenurial security. So legal recognition of plots will empower the workers to uplift their socio-economic upliftment the state government shall take initiative to expedite the distribution of land partners to long-settled workers. Furthermore, providing economic diversification by supporting small tea gardens along with cooperative subsidies and loans can be helpful. Some gender-sensitive reforms are to be recognized significantly, considering that women constitute 50% of the labor force in the tea industry. The least they are entitled to are clean washrooms in nearby distance and just gaps during working hours. Moreover, the revised wages are still not justifiable and need to be increased to meet the contemporary needs. Working hours should be strictly fixed to avoid arbitrary one-sided decisions that are imposed on the workers. The role of the judiciary is also important. The judiciary has also recently played a significant role. Now, I just refer to two cases. The first one is Krishnakoli Tea Estate versus Akhil Bharatiya Cha Mazdoor Singh and another. It is reported in 2004, volume 8, SCC 200. In this decision, in this ruling, this case is significant as it affirmed the business cannot disown or disregard their statutory obligations by claiming financial difficulties, particularly regarding wage levels under the Minimum Wages Act of 1948. And the latter one is a recent decision in the International Union of Food and Agriculture and Others versus Union of India. This case started in the year 2006, finally disposed of in the year 2010, where by an order dated 6th August 2010, the central government was directed to carry out the statutory duties under the provisions of the Tea Act, particularly in terms of sections 16 capital B, 16 capital C, 16 capital D, and 16 capital E within a period of 6 months. Since this was not complied with, the contempt petition was filed, and the Honorable Supreme Court appointed a one-man committee headed by the Honorable retired Mr. Justice Abhay Manohar Sapre, a former judge of the Honorable Supreme Court, by the order of 10 January 2020 to ensure that the dues of the tea garden workers are properly calculated and paid accordingly. In fact, Justice Sapre, he refused to accept the remuneration, and as a noble gesture and magnanimity, the entire amount was paid for disbursement in favor of the identified cases. The court also directed the state of Assam to pay a sum of rupees 35 crores to Assam Tea Corporation Limited by 30th June 2025, and the remaining sum of rupees 35 crores by 30th June 2026. In conclusion, we must ensure fair wages, proper housing, healthcare, education, and strong enforcement of labor laws. True progress lies in collective actions by the government, employers, and civil society to restore dignity and justice to those who sustain this vital industry. The hands that brew the nation's tea deserve more than survival. They deserve dignity, fairness, and a future filled with hope. With collective will, empathy, and a compassionate approach, we can transform the lives of tea workers and honor their contribution to our country's growth. Thank you, Namaskar, and Jai Hind.
I will now request Mr. Owen Chapa, Director, Legal Cell for Human Rights, to share his views.
Namaskar. Honorable Mr. Justice Prasanna Kumar Mishra, the chairperson of today's session, and Honorable Mr. Justice Soman Sen, Chief Justice Meghalaya, the co-chair of today's gathering, and Mr. R. Kota, the Chief Secretary of Assam, the co-speaker of this session, and honorable judges, ladies and gentlemen present here. I, at the outset, would like to sincerely express my gratitude to the Legal Service Authority for giving me an opportunity to be present here to share my thoughts on the topic of discussion today. Secondly, I am grateful to both the chair and the co-chair because they have already done my job. They have already introduced the topic and have extensively spoken on the topic very much. I have very little job to do right now. So I would not I would directly go into the problems. The topic that has been given to me for presentation today is the problems of tea garden workers and the challenges to eradicate them. The problems that tea garden workers here in face are a vicious cycle of socio-economic deprivation, and that's my strong opinion. The problems faced by tea tribes are not isolated issues, but an interconnected web of challenges that form a powerful, self-perpetuating vicious cycle. Among them stands out low wages, which causes poverty, which prevents families from affording education and health care. The lack of education and skill development locks them into low-paying, unskilled jobs, or rather being considered or categorized as unskilled laborers, while poor living conditions and malnutrition lead to chronic health issues, further reducing their productivity and deepening their debt. Tea workers in Assam receive wages that are insufficient to meet the minimum standards for decent living, with their remuneration falling way below Mahatma Gandhi National Rural Employment Guarantee Act. This financial inadequacy poses significant challenges for these workers and their families in meeting essential needs, including access to nutritious food, adequate housing, clothing, quality health care, and education. Consequently, they frequently resort to borrowing from local money lenders or working additional hours, exacerbating their physical exhaustion, mental stress, and overall familial vulnerability. Should the state and tea companies agree to implement a living wage, which is now being discussed in the corridors of the court, it would enable workers to attain a decent standard of living and lead a dignified life. The most pressing challenge is a systemic non-compliance with minimum wage standards, which condemns the community to pervasive poverty. The Comptroller and Auditor General's report from 2019 to 2014 have successively found and stated that tea workers in Assam are being paid the least wages compared to their counterparts in other tea-producing states in India, like, for example, Tamil Nadu, Kerala, Karnataka, and West Bengal. While state government announced a wage hike to 250 rupees in the month of May 2025 for the state-run tea garden workers, which is now in force from 1st of October 2025, this remains significantly lower than the 351 rupees demanded by Assam Cha Mazdoor Sangha, the largest workers' union. Furthermore, a significant wage disparity exists within Assam, with workers in Barak Valley receiving lower wages, that is 228 rupees, than those of Brahmaputra Valley receiving 250 rupees per day. And workers in unorganized sector receive much lower than that. Over 80% of tea tribe workers earn below minimum wage. And for more than a third of the surveyed villages by Oxfam India in 2019, expenditure exceeds income, leading to a state of recurrent debt. The situation is further compounded by a significant gender wage disparity, where women, who constitute the majority of the workforce, earn an average of 80% than what men earn. The second problem that is affecting the tea garden laborers is the substandard living conditions. The community's living conditions are a testament to their continued deprivation. Housing in tea garden settlements is described as dilapidated, overcrowded, and poorly constructed, lacking basic amenities such as electricity, clean water, proper sanitation. Over 50% of the population lives in areas with inadequate infrastructure, which exacerbates the socio-economic divide and contributes to poor health outcomes. Under PLA, all tea estate owner management must provide good housing facility with attached toilet and water facilities to workers. The study conducted by Oxfam, titled In Defense of Living Wages for Tea Plantation Workers, and evidence from Assam 2019 shows that majority of tea workers are still living under a deplorable housing and toilet facilities. The research shows only 28% of people reside in pakka houses. Over majority of 43% stay in semi-pakka, and around 29% live in kacha houses. Indian jurisprudence recognizes housing as a fundamental right to life as enshrined in Article 21. By defining housing as a constitutional right linked to human dignity, the rulings of the court shifts from viewing it as a mere policy issue. Since housing is vital for health and social inclusion, courts have emphasized that neglect breaches constitutional protection of life with dignity. In Ray Tea Garden Workers of Assam case highlighted that failing to provide proper housing facilities violates Article 21 and demanded action to ensure workers' decent living. In Assam Cha Mazdoor Sangha versus Union of India, the Guwahati High Court upheld the constitutional viewpoint, concluding that it was against Article 39E and 43 to deny plantation workers housing and social security benefits. According to these directive principles of state policy, the state is required under the Constitution to guarantee humane working conditions and living wage that is adequate to sustain respectable living conditions. The second problem that the tea garden workers are facing is a safe drinking water facility. Chapter 3, Section 8 of the Plantation Laborers Act provides that every employer is duty-bound to provide sufficient and wholesome supply of drinking water and create convenient locations for people to access safe drinking water and protect the sources of water by constant cleaning and sterilizing. But the studies have found all these provisions not being met at the ground level. More than 50% of the tea workers use tube well or bore well as the main source of drinking water in the tea estates. Around 1/4 of the workers use dug well and only 15% use piped water for drinking. Since many tea estates are located in remote areas, 9% of workers use water from springs for drinking. Inadequate access to drinking water is still a critical issue in many estates, as reported in the focus group discussions during summer. Springs dry up, forcing workers to travel long distance to fetch drinking water. Healthcare is another major problem faced by tea garden workers. One of the most glaring examples of a systemic neglect in the Indian labor regime is the healthcare system's treatment of tea garden workers. The reality on the ground is marked by institutional failure, regularity indifference, and exploitative working conditions, despite the fact that both statutory law and constitutional commitments require comprehensive medical treatment for plantation laborers. Employers are expressly required under Plantation Laborers Act 1951 to provide easily accessible hospitals, medical personnel, and necessary medications in plantation. But the reality is, many tea estates lack operational medical outposts with clinics frequently operated without a staff or with inadequate and out-of-date medical supplies. It is nearly impossible to get timely treatment because the closest government hospitals or emergency rooms are usually located far away. We can imagine the situation of a pregnant woman who has to travel in these conditions to a nearby hospital. A recent study conducted by Assam Medical College Hospital identified significant health concern involving hazardous fungal infection predominantly affects and compromises the pulmonary system of individuals who working in the tea gardens, which are associated with tuberculosis and chronic pulmonary aspergillosis. The Supreme Court intervened suo motu in 2021, acknowledging the seriousness of these health deficiencies and highlighting that denying tea garden workers access to medical care violates Article 47 of the Constitution, which requires the state to improve public health and raise nutrition levels, and Article 21 of the Constitution, which guarantees the right to life with dignity. Furthermore, by connecting the lack of food and medical care to structural forms to laborers that are forbidden by Article 23. The court's handing of the starvation deaths associated with health crisis in starvation deaths of tea garden workers of Assam and West Bengal further expanded constitutional protection. Court acknowledged that economic coercion resulting from lack of medical assistance and basic nutrition is a grave violation of human rights. The next problem that the tea garden workers are facing is a crisis in education and literacy. Section 14 of the Plantation Laborers Act provides if a number of children in a given tea garden exceeds 25, the employer is duty-bound to set up an educational system or schools with adequate facilities in the tea gardens itself. The drivers of low literacy and high dropout rates are systemic and interconnected. They include financial constraints and prevent families from sending children to school, particularly beyond the primary level, as well as lack of educational infrastructure. A shortage of well-trained teachers in rural areas and parental non-literacy. This educational crisis ensures that children of tea garden workers are often deprived of a quality education, which restricts their future employment prospects and perpetuates the cycle of poverty by locking them into the same low-wage, unskilled, and low-paid labor as their parents are. And the fifth major problem of the tea garden workers is a struggle for identity, land, and rights. Beyond the immediate socio-economic challenges, the plight of tea tribes is defined by a fundamental struggle for legal and political recognition. This struggle is a battle for power and is rooted in their colonial origins. The lack of land rights is not an oversight, but a deliberate legal strategy that ensures state of perpetual bondage, while the denial of scheduled tribe status is a calculated act of maintaining the community's disenfranchised state. A contested identity, the demand for scheduled tribe, which Honorable Mr. Justice touched in his introductory remark, the tea tribes have a long-standing demand for scheduled tribe status in Assam, where they are currently classified as other backward classes. This demand is central to their quest for social and economic upliftment as their ancestral communities in states like Jharkhand, West Bengal, and Odisha are already recognized as STs. The community's leaders have also protested the practice of issuing caste certificate that group them. Okay. Thank you. I have been asked to conclude, so before my conclusion, I would like to just make quick points that The very important, another problem that the tea garden workers are facing is the land ownership. The tea tribes are by design landless population. Workers have no legal right or ownership of their homesteads. This precarity is exacerbated by the growing threats of land sales. Activists have protested against the plantation management decision to sell the land for commercial ventures. The challenges in eradicating these problems. One is governmental initiatives, a critical audit implementation. The findings of Comptroller and Auditor General's report on the implementation of the schemes that have been envisioned for the tea garden workers' welfare seem to be ill implemented. And in some of the studies, it has been found that the people in the tea garden have hardly any information about the availability of the schemes. The second one is the role of non-state actors. Non-governmental and international organizations play a vital role in filling the gaps of reaching out to people. The next solution that we can consider, next challenge that we see here is structural challenges within the tea industry. The plight of tea workers is also driven by the tea industry's own economic struggle. Reports from the Indian Tea Association indicate that the industry is at a critical crossroads, facing significant headwinds from declining production due to climate change. The recommendation for a suitable path forward are the following. Under legal and policy reforms, there is a need to reform Plantation Laborers Act 1951 and include the aspect of temporary and casual workers to bring them also under the purview of the provisions of the Plantation Laborers Act so that they could also be provided with the similar wages or entitlements. The second one being land rights. A legal framework should be established to provide tea tribes with legal rights to ownership of their homestead land. Thirdly, identity and political recognition. A transparent and time-bound plan for addressing the demand for scheduled tribe status must be implemented, including clear and public dialogue with all stakeholders. In support of women, welfare schemes should be properly communicated to women and made available to them, and make it available to them in such a way that they are able to easily access. Under the economic empowerment diversification, there is a need, a suggestion, the recommendation is made, a national and regional tripartite mechanism involving government, plantation worker, and worker unions should be established to link tea garden wages to living wage standards. Secondly, to improve the skills of the tea garden workers' children so that they are able to better access entitlements and also have a better job opportunities. In conclusion, the enduring plight of the tea tribes is a complex problem, born from a colonial legacy and perpetuated by a nexus of economic, illegal, and political failures. The current welfare-based approach, while well-intentioned, is failing due to insignificant implementation gap, a lack of awareness, and a failure to address the systemic roots of the problem. The core of the problem lies in the community's lack of fundamental rights, right to a recognized identity, right to a land ownership, right to dignified livelihood. The current system, which treats the community as a dependent labor pool rather than a rightful system, which treats population, ensures that a cycle of exploitation and poverty will continue. True eradication of these problems require a fundamental shift to a right-based model, where community is empowered with legal rights to their identity, their land, and dignified livelihood. Only by addressing the root causes and providing these fundamental protections can the tea tribes begin to build a future free from shadow of their colonial past. Thank you.
I will now request Mr. R. Kota, the Chief Secretary of Assam, to share his views.
Good morning to every one of you. Honorable Mr. Justice Prashant Kumar Mishra, Judge, Honorable Supreme Court of India and Chair of today's session. Honorable Mr. Justice Owen Chapa, Chief Justice Meghalaya High Court and Co-Chair for today's session. Mr. Owen Chapa, Director Legal Cell for Human Rights and my co-speaker for the session. Honorable Judges of the Supreme Court, Honorable Chief Justice of High Courts, Honorable Judges of High Courts, respected District Judges, esteemed members of the National Legal Service Authority, distinguished guests and colleagues. It's a privilege to join you for the session on problems faced by tea garden population and challenges to eradicate these problems. Since previous speakers have very lucidly covered most of the problems and also measures to eradicate these problems, so I don't want to waste your time and I would skip much of my points I have jotted down. But at the cost of repetition, some of the things I may need to repeat as an examples. The story of Assam's formal economy begins in many ways with its tea gardens. The vast green estates stretching across the state are not only the pride of our state, but the roots of India's global identity in tea. Nearly half of India's tea is grown here, yet behind this celebrated industry stands a community that has carried both its glory and its burden for 2 centuries, the tea garden workers of Assam. This year marks almost 200 years since tea cultivation began in Assam. When we look at India's modern economic evolution over the recent past centuries, tea was among the earliest organized industrial economies. It brought tremendous economic impact, creating employment, revenue, and infrastructure for Assam and for the country. But here is the thing, it also came with a very typical colonial design. Large estates, often spanning over 1,000 hectares, were carved out of dense rainforests. Into these plantations, the British brought migrant laborers, men and women from the Chota Nagpur Plateau, Odisha, Jharkhand, Bihar, and other parts of eastern India. They were indentured, bound by contract and circumstance. They were settled in these estates, isolated islands where life revolved entirely around the rhythm of plucking tea leaves and running tea factories. Their wages came mostly in kind, a little in cash. Every week they went to the local Haat Bazaar to spend what they earned, often on local liquor, only to return the next morning to the gardens empty-handed. It was an economic cycle carefully engineered to tie them permanently to the estates. Over time, what emerged was not as an industry, it was a distinct society. Even after independence, this inherited isolation persisted. While the rest of the country industrialized and diversified, tea garden communities remained locked in a plantation economy that was paternalistic, dependent, and slow to change. In a sense, the tea gardens mirror India's own larger journey from colonial subjugation to self-determination. Just as we have replaced colonial criminal codes with the Bharatiya Nyaya Sanhita, freeing our justice system from its colonial scaffolding, we must also rethink how we address communities that still carry the weight of those old structures. The BSNS is not just a legal form, it's a reminder that every Indian is central to the nation's progress. Every citizen deserves equal opportunity, dignity, and access to justice. It is that same spirit that we must approach Assam's tea garden population, not as a relics of an older economy, but as partners in development, who deserve full social and legal inclusion. Until about 2 decades ago, life in Assam's tea gardens was much as it had been since colonial times, harsh, unequal, and cut off from the rest of the society. Women who make up the kind of a problems of wages, housing, health, water, sanitation, those all have been explained already, malnutrition, anemia, etc. Now, women, I would like to mention a couple of things because they make up most of the workforce, carried the greatest burden facing wage discrimination, lack of maternity benefits, and exposure to harassment and domestic violence. Poor documentation meant that only a few had Aadhaar cards or bank accounts, leaving many families outside the net of social protection. And when estates turned insolvent, workers were left without wages or any safety net. That was the reality for decades. But the last 10 to 15 years, where we have been personally involved in this process from the state government side, could see some visible and measurable changes. As I said, it's slow to change, but at least it has begun. Almost every major social and financial indicator has improved. Financial inclusion has deepened. State governments were earlier not entering into the tea gardens for any kind of a developmental works, but roads, schools, water supply, those kind of a things we started doing. While doing so, the kind of a land and managerial issues are there in the tea gardens. So there are the challenges for the state government. The journey is so far from complete, but the direction is clear. Today, about 20% of Assam's population, both workers and the dependents, about 7 million people live nearly 800 tea gardens and adjoining areas. They remain the backbone of an industry. So when it comes to the legal framework, various acts, Plantation Labor Act onwards, other things have already been discussed. I would not like to repeat about them. But I agree that implementation remains inconsistent. Labor departments are understaffed, inspections are infrequent, and managements frequently cite market distress to delay compliance. The wage point raised by my previous speaker is something which state government has always been insisting with the managements, but when it comes to the payments, the productivity of the tea gardens and their existing geographical areas, these are all quoted as reasons. But judicial oversight has been crucial. In fact, one of the case, what Chief Justice of Meghalaya High Court mentioned, Union of Food and Agriculture Workers was State of Assam. In fact, I was personally summoned to appear before the lordships in the Supreme Court in April last. So to explain why the state government can't pay this. So it's a technical point. What we were taking before the Honorable Court was, it's a PSU and we didn't want to pay from our state exchequer, and state PSU is responsible for this thing, and they can sell their property, dispose of something, they can pay. That was the point what we were taking before the court. But the court was finding it difficult to accept that argument and finally directed us to pay 70 crores. So that in 2 installments, 1 installment we paid and 2nd installment we are paying. But that kind of an intervention, ultimately, if we see the end of the justice, not as a state government we represented before the court, but if we see as a requirements for the wages to be paid. So those kind of a judicial interventions have been quite useful and also give a direction to the state governments and all other stakeholders. When I come to the state government's interventions, I would like to mention one thing. I was Principal Secretary Finance when demonetization was announced. That was on 8th November 2016. When the Honorable Prime Minister announced demonetization, it triggered anxiety across the tea gardens. It was festive season and the wages were due. The currency withdrawn overnight, and then we transported them into various chests into different parts because there was a genuine risk of unrest. For the next 72 hours, we worked closely with Reserve Bank of India and other banks to move the chests under police protection, and valid denominations were supposed to be organized for distribution in the tea gardens. At the time, we realized that there are no many people didn't have any bank accounts, no Aadhaar, no ATMs nearby. That moment became a wake-up call, and since then the financial inclusion drive had made remarkable progress. Today, almost every worker has an Aadhaar card and bank account, and wages are increasingly routed through formal channels. Another crucial step has been wage compensation for the pregnant tea garden workers. Tea estates have long contributed disproportionately to Assam's maternity and infant mortality rates. Women would work until their last days of pregnancy because missing work meant losing pay. When in 2016-17, the Honorable Chief Minister was himself is the Finance Minister. I had the privilege of working in that with him and envisioned an innovative intervention. Under this scheme, the government compensates women for the wages they would have earned in their last trimester, so allowing them to rest and recover without financial loss. It has saved lives of both pregnant mothers and also infants, bringing dignity to women labor. So there are other important schemes. Of late, Government of Assam has been implementing now. There is a new scheme this year. We started implementing Etikuli Dutipat scheme, that is one bud and two leaves. 5,000 rupees direct transfer to nearly 7 lakh tea workers. Then there is an Arunodai scheme where monthly income support to women from poor households, including tea families. Earlier, the tea gardens were not included. There are a Pradhan Mantri Chasramik Yojana and also Nijut Moina scheme. Nijut Moina, it's a million girls scheme where that girls are encouraged to go to the secondary education, higher education, the monthly payments are made to them. Similarly, the Jal Jeevan Mission and the Swachh Bharat, these were the things which were earlier not implemented in the tea gardens. Now we were trying to do as much as possible despite of the vastness of the places. Then also high schools near the tea gardens have been planned and being implemented to reduce dropout rates. Then mobile clinical vans, more than 600 of them have been deployed because organizing proper hospitals along with them, the doctors deployment has been a challenge. Mahatma Gandhi National Rural Employment Guarantee Act was not implemented earlier in the tea gardens. Now we started doing that. Then in state government has made special provisions for 3% reservation for the grade 3, grade 4 posts for the tea community youth. The list is long, but for the sake of the time, I would like to mention the one point that I could see last 30 years and odd in my service in Assam cadre, things are changing. And today it's a very critical moment because NALSA and this kind of a high profile workshop where we are discussing with such an intensity. And also yesterday, legal aid clinics have been inaugurated in some of the places. So with this combination, perhaps we'll be able to further leverage the legal interventions and legal services through various kind of, we can go to the next leap. So legal awareness, access, identity and documentation of individuals, that has to come from the state government. Women and child rights, wage and welfare claims, estate insolvency and worker security. These are the areas perhaps we have to focus together, the governments and the legal services authority. Mediation and dispute resolution, land and livelihood rights, because that support land patta distribution and self-help groups, entrepreneurship through legal facilitation is very much important. Of course, judicial oversight is something given, and only that how we can encourage periodic monitoring by various legal services committees is something perhaps we have to take forward. And but this conversation is not only about tea, it's also about justice. If the country can move beyond colonial laws through the BNS, we can also move beyond colonial labor structures that still shape life in our plantations. Legal services must not remain reactive, they must become proactive instruments of empowerment. And let me close with a reflection from my own journey in last 32 years in the government, nearly 10 years I spent in the field, most of it in tea gardens areas of Golaghat, Sivsagar, Jorhat. I still remember an evening back in 1999 during the total literacy campaign in Golaghat district. We would visit the labor lines after dark, sitting with the workers, encouraging them to learn to read and write. One evening I insisted that the local tea garden manager accompany me. Educated in Doon School, he came reluctantly, and as he walked through the narrow lanes, he quietly said, "This is the first time I have ever visited the labor lines." That sentence has stayed with me for years. It spoke volumes about the distance that once existed between the management and the workers, between the privilege and labor, between law and life. Between law and life is something what the Honorable Judge Mr. Justice Surikant mentioned yesterday in his speech. But today, the distance is narrowing. The same tea gardens have now student unions, self-help groups, and panchayats that interact directly with the government. I have met some boys and girls, as bright as any Indian boys and girls from those same labor lines now, who are now MLAs, even some are doctors, engineers, and civil servants. The change is real, but with stronger legal awareness, wide access to justice, reforms like BNS shaping new ethos of equality, I believe we can complete this transformation so that every tea garden in Assam becomes not an island of isolation, but a community of dignity, opportunity, and justice. Assam's tea industry may have been born out of a colonial economy, but its future can represent India's most humane and inclusive vision. The men and women who picked those 2 leaves and a bud have already given their labor to build the country's economy. It is now for the law and the government and for us to give them what they have always deserved: dignity, equality, and justice. If our legal services institutions can continue to make that bridge between rights and reality more effectively, then we will not only have enforced the law, we will have redeemed history. Thank you so much.
Thank you, Justice Somen Sen, Mr. Owen Chapa, and Mr. R. Justice Somen Sen highlighted the plantation provisions of the Plantation Labor Act 1951 and the shortcomings. He put forth the analysis of the Minimum Wages Act and the wage problem with which the plantation workers are facing, the income insufficiency, the living conditions, and the healthcare facilities. Then Mr. Chorappa highlighted about the vicious cycle of the problem faced by the workers, particularly the wage problem, the drinking water problem, and health, sanitation, and education problem. Then the Chief Secretary, Mr. R. Kota, he focused about the social protection of the tea plantation workers, highlighting the challenges for the state government and admitting that much has been done, but much more is required to be done. He said he outlined the state's effort to improve the living conditions, which includes health, education, sanitation, and drug abuse, all such problems with which the plantation laborers are facing. The crux of the problem lies in how to take them out of such problem. And at the grassroots level, who will highlight that problem and bring it to the notice and knowledge of the concerned authority. And this is where we, NALSA, its entire paraphernalia, including paralegal volunteers and those who would be manning the legal aid clinics, they will come to the rescue. Together with the coordination of government, judiciary, civil society, and private industry, we can forge a new era of inclusive development, where every drop of sweat spent in the tea garden is honored with justice, dignity, and opportunity. Now we have little time, but still we can take a few questions, and I will invite the audience, if they have any questions relating to the topic, they can just post to us.
Very grateful to the learned panel for the deliberation. I come from the state of Assam. though my ancestral roots are from Lower Assam, the gardens are mostly located in the Upper Assam. I have worked in the district judiciary, and during my work in the district judiciary in districts like Jorhat, I've heard numerous occasions from people in the police and administration, and even in the crime conferences also, this has been talked about, that recent times, one very disturbing thing which is happening in the tea gardens is a lot of suicides. I do not know about the ground situation, because this is only I have heard, and I have in the crime conferences, as I said, the SPs and the DCs have discussed this with a lot of concern. And not only that, they say that many of these suicides are of very young people. So I mean, if that would be related to our next topic also, mental health. So so this aspect can be delved into, because as we would all agree that suicide is it's a terrible human tragedy, and if the sorrows of life would justify taking of one's life, then all persons in suffering will have to end their lives. So suicide is nothing but a distress call which has gone unanswered. So therefore, I think maybe Chief Secretary, this aspect, if this true, and what is the magnitude of this problem, and definitely I think legal service authorities can also do a lot about addressing these issues and preventing this kind of tragedies. Alcohol is already a problem, especially in the older generation, but this aspect I thought I just flag it. Thank you.
Suicide, as we know, is a social problem, is a psychological problem, and it's a problem which is connected with emotions and sentiments also. But as we again go down and discuss, the root cause is the living condition. A person feels depressed when he is pushed to the wall in his life and his aspirations are not satisfied. The aspirations in life being a relative term, even a person who is well off has higher aspirations than at the place he is situated. But still, the minimum what we can do to uplift their living standard is the root cause. And once we achieve that we have done something for those living in the tea estates, the plantation workers, and if their lifestyle is removed and the problem of substance abuse and alcoholism is dealt with effectively, then probably we may get over this problem of suicide. It can be minimized. This being a human problem, mental problem also, it can't be totally eradicated, but we can minimize the instances of suicide. Thank you.
Our heartfelt thanks to each one of you for your commitment to enriching this conversation and driving awareness on such a critical subject. And ladies and gentlemen, due to paucity of time, we would now proceed with the fifth session of the day. Tea will be served here in the hall itself. We would just take a minute or so to do up the stage. Thank you so much. Court of Assam, Nagaland, Mizoram, and Arunachal Pradesh, I would like to extend a warm welcome to you all to the 5th technical session of the National Legal Services Authority East Zone Regional Conference of 7 northeastern states and Sikkim, Bihar, West Bengal, Jharkhand, and Odisha. The designated topic for the session is mental health and legal aid. Mental health and legal aid are two critical yet often overlooked pillars of a just and inclusive society. Individuals facing mental health challenges frequently encounter stigma, discrimination, and barriers to accessing justice. Many are unaware of their rights or lack the support needed to navigate legal processes. Ensuring accessible legal aid for persons with mental health issues is essential to protect their rights, promote dignity, and support their rehabilitation. This conference aims to shed light on the intersection of mental health and legal support and to strengthen both systems in a more compassionate and rights-based manner. Ladies and gentlemen, to get more clarity on the topic, we are honored to have Honorable Mr. Justice Vijay Bishnoi, Judge, Supreme Court of India, to chair this session. I'd request you, sir, to kindly take your seat on the dais. His Lordship is being escorted by Srimati Moshumi De, District and Session Judge, cum Chairman, DLSA, Bongaigaon. Honorable Mr. Justice Vijay Bishnoi was appointed as a judge of the Rajasthan High Court in 2013 and later as the Chief Justice of the Guwahati High Court. His Lordship was elevated as a Supreme Court judge since 2025. This session would be co-chaired by Honorable Mr. Justice Talok Singh Chauhan, Chief Justice, High Court of Jharkhand. I would request Srimati Hongita Gogoi Bora, District and Session Judge cum Chairman, DLSA Dibrugarh, to kindly do the honors. Honorable Mr. Justice Talok Singh Chauhan was appointed as a judge of the Himachal Pradesh High Court in 2014. His Lordship has served twice as acting Chief Justice and was appointed Chief Justice of the Jharkhand High Court in 2025. The keynote speakers of this session would be Honorable Mr. Justice B.P. Kotoki, retired former judge, Guwahati High Court, to be escorted to the dais by Shri Chandrangshu Chaturvedi, District and Session Judge, cum Chairman, DLSA, Chirang. Honorable Mr. Justice B.P. Kotoki served as a judge of the Guwahati High Court from 2004 to 2014. His Lordship held several key legal roles for both central and state governments. Post-retirement, His Lordship served in the Central Administrative Tribunal and Armed Forces Tribunal and currently chairs the State Police Accountability Commission in Assam. Dr. Rajalakshmi Jooshi, ILS Law College, Pune, to be escorted to the dais by Shri Sandeep Kaushik, Secretary, DLSA, Majuli. Dr. Rajalakshmi Joshi holds LLB, LLM degree from ILS Law College, Pune and PhD in Mental Health and Law. She has been teaching at ILS Law College, Pune since 2014 as an assistant professor. Her areas of interest include arbitration and disability rights jurisprudence. She has to her credit various publications. She has co-authored articles on mental illness and right to property, which have been published in International Review of Psychiatry and International Journal of Social Psychiatry. Indeed, a fabulous set of panelists apt for the discussion on the given topic. Now, we would like to felicitate our esteemed guests on the dais. We would first felicitate Honorable Mr. Justice Vijay Bishnoi, Judge, Supreme Court of India. I'd request Srimati Honkori Das, Law Secretary, Government of Tripura, to kindly do the honors. Thank you. May I now request Shri Satya Prakash Sinha, Registrar General, Honorable Jharkhand High Court, to kindly felicitate Honorable Mr. Justice Talok Singh Chauhan, Chief Justice, High Court of Jharkhand. Thank you. May I now request Shri Ratnadeep Bhattacharjee, District Sessions Judge cum Chairman DLSA Dorong, to kindly felicitate Honorable Mr. Justice B.P. Kotoki, retired former judge, Guwahati High Court. Thank you. We would now felicitate Dr. Rajalakshmi Jooshi, Assistant Professor, ILS Law College, Pune. I would request Srimati Pranita Morong, Joint Registrar Vigilance, Guwahati High Court, to kindly do the honors. Thank you. I would now hand over the session to Honorable Mr. Justice Vijay Bishnoi, Judge, Supreme Court of India, the chair of the session, to kindly commence the proceedings. The duration of the session is 1 hour 15 minutes. 15 minutes for the interactive session. On to you, sir.
Honorable Mr. Justice Suryakant, Executive Chairman, National Legal Services Authorities, and Judge, Supreme Court of India, Honorable Mr. Justice Prashant Kumar Mishra, Judge, Supreme Court of India, Honorable Mr. Harish Chandan, CJ, Odisha High Court, Honorable Mr. Sumen Sen, CJ, Meghalaya High Court, Mr. Pawan Bajantri, CJ, Patna High Court, Mr. Sujoy Paul, Acting CJ, Calcutta High Court, Mr. Sundar, CJ, Manipur High Court, Mr. M.S. Rao, CJ, Tripura High Court, Mr. Talok Singh, who is also co-chairing this session, Chief Justice Telangana High Court, Jharkhand High Court, and the host of the program, Honorable Mr. Justice Ashutosh Kumar, Chief Justice, Guwahati High Court, my brother and sister judges of the Guwahati High Court, and I got this opportunity to meet all of these persons, were wonderful persons here, sister and brother judges. Of course, Mr. M.R. Pathak is also here, Manas Pathak, who is also my former colleague, Mr. Senior judges from the various high courts who are attending this program, Mr. B.P. Kotoki, the former judge of the Guwahati High Court, who is also one of the distinguished speakers in this session, Dr. Rajalakshmi Joshi, Assistant Professor, ILS Law College, Pune, the various advocate generals present in this session. Good morning to all. I have strict instructions from the Chief Justice Ashutosh that to conclude this session by 12:30, otherwise he will not allow us to board the return flight. So I request all the distinguished speakers, we have to conclude this session by 12:30. In fact, from last 1.5 days, we have discussions on various topics which are important. However, the present topic, mental health and legal aid, is no less important. In today's world, amid rising competition, increasing suicide rates, and demanding work schedule, discussions about mental health have become very critical. As behind many smiles, there are silent struggles, anxiety, stress, and depression. Today's topic, mental health and legal aid, holds immense relevance in our developing society, where the importance of mental health well-being is frequently overlooked. You can see mental health is a state of mental well-being that enable people to cope with the stresses of life, realize their ability, learn well, and work well, and to contribute their community. Mental health conditions include mental disorder and other mental states associated with significant stress and impairment of the functional normality. We often perceive mental health and mental illness as the same, but in reality, they are distinct concepts. Mental health is about wellness, whereas mental illness is about sickness or disorders that disrupts that wellness. Mental illness is not a personal failure or weakness, yet the stigma surround it leads to a fear of discrimination and reduced opportunities within the society, which results in avoidance of help and resources. Our mindset is that if a person is suffering from some mental health, we always say in very general parlance, he is having some mental problem, and often we say, pagal hai. So we have to shake off this mindset. In fact, in a way, everybody is suffering from some mental stress or mental health problem is everywhere. I may have some other problem, I may have work-related problem, I may have health-related issues, I may have the, you can say, family problems. So mental stress or mental disorder can come in a life of a person in many ways. Now today we gathered here that how to help those persons who are suffering from or whose mental health is not up to mark or in order. In this regard, Article 39A of the Constitution, introduced by the 42nd Amendment in 1976, mandate equal justice for legal aid for all, irrespective of economic or other disabilities. Similarly, Section 12D of the Legal Services Authorities extend free legal aid to the persons suffering from mental illness. There are various schemes by the NALSA. One such of the scheme which was introduced only in 2024 is NALSA, Legal Services to Persons with Mental Illness and Persons with Intellectual Disabilities Scheme 2024. NALSA operates a national helpline toll-free for the persons suffering from this, that is toll-free number 151000. NALSA's Jagrati scheme, which aims to promote equal justice for institutionalizing legal and awareness through local bodies. Samvad is a national initiative under the Ministry of Women and Child Development, Government of India, that aims to enhance access to justice for all. Telemanas is a national telemental health program of the Government of India, which aims to provide free 24/7 telemental health services across India, especially for remote, underserved, and vulnerable population. Inclusion of mental health services integrated into the Ayushman Bharat Comprehensive Policy healthcare model. Today we have to discuss that how to deal with this problem of mental health and how to provide the legal aid to the persons suffering from that. In the Act of 2016, that is Right to Persons with Disabilities under the Right of Persons with Disabilities Act 2016, and the Rights of Persons with Mental Illness under the Mental Health Care Act 2017, there are various provisions which cast a duty upon the judicial officers, the paralegal volunteers, the police officers, how to protect the rights of the persons who is suffering from mental illness or is having a problem regarding his mental health. We have two very distinguished guests today with us. Mr. Justice B.P. Kataki, former judge of Guwahati High Court, who has also given a very wonderful and excellent write-up provided for on this subject. Dr. Rajlakshmi Jooshi, Assistant Professor of Law College, ILS Law College, Pune, And of course, Justice Trilok Singh Chauhan, who is having experience of so many years as an advocate as well as a judge. And so I start this session with the discussion. I would like to invite Honorable Mr. Justice B.P. Kataki to present his presentation. Sir.
Honorable Mr. Justice Surya Kant, Judge, Supreme Court of India, and who is the guardian of NALSA, and because of him, we are here today and got the opportunity of being present amongst you today. Honorable Mr. Justice Bishnoi, Judge, Supreme Court of India, Honorable Chief Justices of various High Courts, Honorable Judges of various High Courts, and most importantly, my dear participants. I retired from service, active service as a judge in the year 2014. After retirement, one of my friends asked me, "What are you doing now?" I told him that I am working for the legal aid of the inmates who are in jail and also working for the benefit of the person who are suffering from mental illness. He was very surprised. Legal aid for those criminals? Legal aid for those pagals? The pagal word is being used, still used. That is the perception of the persons with mental illness in the society. It's very common sight in the society, how we behave with a person with mental illness. We neglect them. Definitely we neglect them. I have prepared certain charts because I have been told that time is very limited because of this. 2017 Act was enacted 3 years after my retirement as a judge. After retirement, as I said, I started working in jail, and while visiting different jails in Assam, I have found that certain persons are still languishing in the jail who are mentally not sound. Even they have been not given the legal protection of unsound person with unsound mind. I have come across even a case where a person was sent to the regional Center for Mental Health Establishment, Tezpur, and he was sent back from there. And then the judicial process started. The trial recommenced against him without there being a judicial order. That order was passed by the solicitors accepting whatever was said by the director of that mental health establishment. Those things, in fact, disturbed me very much. Then I thought that I should study something about the mental health Care Act 2017. So therefore, I am still learning what is there in 2017 Act. For the benefit of the various stakeholders, we know there are various stakeholders right from the police to the Mental Health Review Board. I have prepared a note, detailed note, and in that I have been told that my detailed note has been circulated to each one of you, means the participants. There you will find that page 10 and 11 particularly, I have segregated the duties and responsibilities of each of the stakeholders for your benefit, because all of you have these additional charge of doing justice to the mentally ill persons. You are already overburdened. All judicial officers are already overburdened. The caseload is tremendous caseload before you. You have to deal with it. You have to, apart from that, you have to deal with the other aspect, because nowadays the phrase that you have to do the best is no longer valid. What is nowadays is valid is you have to do better than your best. And for that betterment, we means including me, I have a responsibility to do something for the betterment of the society. So for the purpose of making it easy to understand, I have segregated the duties and responsibilities cast on each of the stakeholders under the Act. As we all know, Section 27 of the Act provides that legal aid has to be provided to the persons with mental illness. We all know what are the rights of a person with disability under the 2016 Act. Why the legal aid is necessary? Legal aid is necessary because we have 25%, at least 25% of the population living below poverty line, maybe 25, 26% of the population are the illiterate. Like the legal aid, which are being provided to the poor and illiterate person, the legal aid to be provided to the mentally ill persons is specialized. It requires the change of mindset of each of the stakeholders. You have to be compassionate. You have to try to understand the difficulties of the person, because he is not a person, normal person, that he will behave with you normally. So therefore, your behavior should also be that he accepts you as a caregiver. You have to accept. Unless you are accepted by the person to whom you are seeking to give the legal aid, you will not be successful. I will not be successful in achieving the objective of the 2017 Act. The various schemes are being framed, including the two important schemes to my mind, 2024 scheme, NALSA scheme, and 2025 NALSA scheme. 2024 NALSA scheme basically deals with the persons with disability, and 2025 scheme, NALSA scheme, basically deals with the legal awareness. These two schemes, 2024 and 2025 scheme, to my mind, are to be, operated in the same field for the purpose of the legal aid to the mentally ill person. And for that matter, the taluk level district committees are to be activated, because 2025 scheme says that taluk level district legal service committees have all the responsibility of implementation of awareness. The PLVs are required to go house to house. But unfortunately in Assam, though we have a number of administrative and the judicial subdivision. We have only 2 taluk level district committees in Assam, that is one in Bajali, which in fact is a district now, and the other is in Rangia. We don't have the taluk level district committees. I have already spoken to Honorable Mr. Justice Michael Jothangkoma on that subject and requested him for the purpose of taking steps for constitution of taluk level district committees for the purpose of implementation of 2025 scheme. The social stigma it has attached to the mental health persons that debars the families from disclosing that anyone in their family is suffering from mental illness. What's social stigma? Because I'll be excommunicated, the entire family will be excommunicated from the society. There will not be any marriage in my family having one mentally ill person in my family. Nobody will visit me, and so on and so forth. So with that social stigma, why should I disclose that one of my member in the family is suffering from mental illness? So therefore, our responsibility towards the society, towards each of the such family is much more than the responsibility of giving the legal aid to a normal, illiterate, and persons living below poverty line. In the next slide, please. I have also highlighted the percentage. Next one, yes. Kindly see the mental health issue, the persons suffering from mental health issues in 2015-2016 statistics, that is the last statistics on which I could lay my hands, is that 15% of the population at that time was suffering from mental health issue of this or that reason. That means 13 crore population was suffering. And most disturbing is the 70 to 92% population are without any treatment. They didn't get any treatment. And most disturbing is we don't have even one psychiatrist per lakh population in India. We have 0.75. I have visited a number of jails. In jails, except in one jail in Nagaon, special jail in Nagaon, there's no psychiatrist. The person who is posted in a special jail in Nagaon, he's a psychiatrist, thank God. But other than, there is no other, I have not come across any jails in Assam. There's a set of rules framed under 2017 Act, which requires that at the time of entry into the prison, every person's physical and mental health is required to be checked. This is being violated with impunity. Nothing has been done. I made an inquiry, what is the situation in other other states. My feedback is that other states is not a better position. They are also suffering from the same thing. The benefit of telemanas benefit, only maybe 4.7 lakh calls they have received out of that almost 20 crore population who were in 2017 were suffering from various mental health issues. That means 1 in every 7 Indians are suffering from mental health issues. But we are not being able to give any relief to them. And poverty and the socio-economic disparities are some of the causes for such mental health issues. Next slide, please. The suicide is we know the third leading cause of the death in worldwide. And in India itself, in 2022, as per the available data, more than 171,000 suicide cases are recorded. 71% of the suicide cases in India are of the age up to 44, the very prime age. 13,000 students take their life annually, and which led to passing of a very famous judgment very recently by the Honorable Supreme Court, where it says that mental health care is emanated from the right to life. So if it comes within the purview of Article 21, then that is their fundamental right to have the mental health care, but we have not been able to so far provide it. But I'm not blaming anyone for that purpose. I know everybody is making an effort to achieve the objective of granting that relief to which the person with mental illness deserves. Next slide, please. In jails, this is 2022 prison statistics. 2023 prison statistics is also out very recently. There is no difference as such, much difference. It was more than 9,000 persons are in prison. 63,000 prisoners, under trial prisoners suffering from mental illness. 35%, more than 35% convicts are suffering from mental illness. And this would be around 9,100 as per the mental prison statistics of 2023. So it's not very happy. Under the 2017 Act, no one who is suffering from mental illness can be in prison unless that prison has a psychiatric ward. I have not come across any jail in Assam having a psychiatric ward, but they are still in jail. They should be transported to or transferred to the mental health establishment. The entire picture is not clear. So therefore, what is required to do is the legal awareness. Legal awareness is a must, and that legal awareness has to be conducted by the PLVs, the LADCs, the taluk level district committees, the district legal service authorities, the state legal service authorities, and the NALSA. They are doing their part. They are performing their duties. But we have to take it forward, and along with the help of the NGOs. The help of the NGOs is very much necessary because it is not always possible for the government to provide all what is required to be done. The people has to come forward and do their part of their duties. Every citizen has a duty to educate the person who doesn't know about it. In the previous session, it has been mentioned that there are beneficial legislation, beneficial schemes, but it has not been percolated to the targeted people. I will even tell you one instance. When I was in Police Accountability Commission, one person came to me for lodging a complaint against the police, which is not maintainable before me in the Police Accountability Commission, relating to a motor accident. His grievance is that the report which was required to be given has not been given to him. I asked him whether he has approached the Motor Accident Claims Tribunal. He is an educated person from Guwahati. He said, is there any provision to claim compensation under the Motor Vehicle Act? He didn't know anything about that. When a person, say educated person from Guwahati do not know about the benefit of a particular enactment, how can we expect that 25% or 27% illiterate or below poverty line persons know about their rights? Next slide, please. Telemana scheme, as per the report of 2024, so far has not been achieved the objective. So also, please next slide, please. Next slide, please. These are the rights under 2016, and I have narrated that 2017 also. Next, 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 next. The last one, way forward. Kindly come to the last one. Yes. What is required? Previous. What is required is a concerted effort of all stakeholders for proper implementation of the provision of the Act, because if one of the stakeholders misses its responsibility, the entire thing will go. The presence of Mental Health Review Board in Assam, in cluster of districts as per the law, one Mental Health Review Board is constituted. Like the Mental Health Review Board of Kamrup district, it has jurisdiction over 8 districts, including Karbi Anglong. You cannot expect a person from Karbi Anglong to come to Guwahati to take the help of Mental Health Review Board. So therefore, what I suggest is this Mental Health Review Board must have at least one office in each of the district under his jurisdiction, so that he can be communicated. Then it has to be handled with human touch. All stakeholders are to be trained to deal with the persons with compassion, calmness, and avoid confrontation. Must have the patience to hear whatever the person concerned says, so that he gains confidence on you and believe in you. And the social stigma attached to mental illness being age-old, it will definitely require time to overcome and cannot be erased soon, for which the dedication of the person is required, apart from the consistent effort. Next, please. 2024-2025 scheme, I have said, the constitution of TLSC and the DLSA, MHRB, I have said so, and the maintenance of checklist by each of the stakeholders as per the duties and responsibilities, which I have narrated at page 10 and 11 of my note, so that they do not miss anything, and so that all the benefits are being calculated to the persons to whom they are entitled to. Thank you. Thank you very much.
Thank you, Mr. Justice Kataki, for this wonderful presentation. So, Justice Kataki has highlighted the problems which the persons suffering from mental illness are facing in the day-to-day life, and has also suggested that we, all the stakeholders, have to work in tandem with each other, and our responsibilities towards the persons with mental illness, how to deal with them. And he also shared his personal experiences. Thank you very much, Mr. Kataki, for giving this wonderful presentation. Now I'll request Dr. Raj Lakshmi to give her presentation on that subject. Sir.
Hello. Yes. Honorable Justice Suryakant, respected dignitaries on the dais of the dais, honorable invitees, ladies and gentlemen, a very, I would say, good morning. No, it's still a good afternoon. I come from 2 institutions from Pune established by Indian Law Society, that is ILS Law College and Center for Mental Health Law and Policy, which extensively work in legal aid and mental health law and research. And I really congratulate the organizers for having this theme on, though the last theme on today, in this 2-day conference. Considering the time in hand, and since I'm also bound by the precedent quoted by Honorable Lordship, I would keep my presentation very short, and I'll make 4 points here to develop a perspective as to how we all as implementers of Legal Services Authorities Act should have a different idea to look at disability as a broader perspective, and then of course mental illness and health to be specific. I would like to specifically say that my presentation is not about provisions of law. On the contrary, I am standing here to challenge the notion of normality and our obsession with normality that we carry, and that will bring us to, bring us help, a perspective of looking at mental health or disability issues differently than what we as able-bodied looks at. As we move ahead, I would like to engage my audience for 30-second activity. Being a teacher, I can't help involving my students into the whole dialogue that I'm having. The 30-second activity has just one rule. I'm going to show you a picture, and after I show you the picture, I'm going to make some observations about the picture. If you agree with that observation, please raise your hand. If you don't, you need not raise your hand, and that's going to take 30 seconds. Here is the picture. No thoughtful consideration is required, and here we go. I notice that all are disabled people. Please raise your hand if you agree. All are disabled people. Okay, I can see few. I notice that all are physically disabled. Okay. I did not notice, I'm saying I did not notice, that people here with disability are looking independent and happy. Do you agree? Please raise your hand. That will help me set the tone. Thank you, judges. I did not notice that they are all well-dressed. Probably we did not observe that. I did not notice that they are likely to have mental disability and not just physical. Yeah? Please understand, mental disability is invisible, and that puts them at the lowest, or at the bottom of the ladder, unlike persons with physical disability. And lastly, I did not notice that they are all human beings, except the dog, of course. Do you agree? Probably that is something never comes to our mind when we are looking at persons with disability. Probably none of us even noticed that I used the word disabled people by putting their disability as their identity before their personhood. So let us call them as persons with disability, the person-first approach, rather than focusing on their disability that becomes their identity. Now, why does this happen? And how I'm going to challenge this notion of looking at people with disability. Firstly, I will not get into the binary of mental and physical, because that goes against my own notion of disability is disability. Binaries are required maybe for the purposes of implementing rights, but let us first understand what is disability. And that actually goes to, what answers we had just now, that's about it's us versus they, and we are failing to look at as we, as human beings. So let us try to challenge this divide of us versus they. So why that perception? Because probably we have still not understood the question, what is disability? And it all depends on the approach. Are we looking at disability as a defect or diversity? The moment our approach to disability as defect to diversity changes, I believe the legislations in India of 16 and 17 referred by my co-speakers will be equally implemented for those groups of disabled that we keep on labeling. As I get less time to speak, I have more pictures to show. I see a person on a wheelchair. The notice says, everyone welcome, and the person can't go. Now, if we look at this scenario from a doctor's perspective, the medical model, they will say, look, the problem is with you because you do not have legs, so you can't go. So get yourself cured, right? You get some crutches, get prosthetics, and then you will be happy. But however, this is the wrong notion to look at disability inside the body and mind. On the contrary, the disability lies outside the body and mind. And therefore comes a social model of disability which says the stairs are the problem. The legal complicated provisions are the problem. The way trial happens as per Code of Civil Procedure or the other laws is the problem, and not my impaired mental capacity is the problem. So from medical model to social model says disability is not within the body. It is into the barriers around us, and it is in the structural environment and attitudinal barriers which creates disability. So let us understand where impairment creates or interacts with barriers which we have created for the majoritarian class of able-bodied that makes a person disabled. If we consult disabled people more on such gatherings where they say nothing about us without us, they have objection of being called as disabled people. They say we are disabled by society and not our impairments. So let us look at how this structure works if we have a wrong idea of disability as a defect. So unfortunately, the legal system that we follow, that we have, the legislations, it equates disability with illness. And on the contrary, illness is not disability, impairment is not disability, but its interaction of impairment with barriers is a disability. But unfortunately, the laws focus more on the person and his issues rather than the barriers that is generating the issues. So let us try to understand that if we change our focus, disability becomes a transitory concept. So very often during training programs, we ask everyone wearing a specs to remove it and try reading a slide. You are disabled maybe. To close the eyes and see my presentation, you're probably disabled. So let us understand disability is a transitory concept, and all of us are disabled at some point or the other. What we have to also understand is the impaired mental capacity to do something is task specific. A woman who is probably suffering from mental illness may not be enough capable to do a job, but that doesn't give us a right to presumption that she is not enough capable to take care of her child. So probably if we are dealing with a custody matter, we can't just label her with a prescription to say, look, you are mentally disabled, so you can't do anything in the world. So let us understand that it's a transitory concept and it is task specific. So I would say a person with visual impairment can read with Braille. He can hear and enjoy the movie with subtitle. He can go anywhere with ramps, and he can still stand a trial and make a contract, make a will if support is provided. Now, why we have so much negative idea about disability? Because none of us will be very happy the moment we say, oh, he's a disabled person, correct? Because we carry that negative approach to the idea of disability because we are still stuck at obsession with normality, and disability is something that you lack ability. So there are two things called as ableism and sanism. Very simple, though complex words. Ableism is a structure, belief attitudes that all people with able-bodied carries, where they say somebody who doesn't fit into our structure is not different, but disabled. Okay? If I can't probably climb these stairs, I'm disabled, right? But if you built a ramp, I can come here and talk. If you provide me with Braille, I can still give this presentation even if I'm not probably fitting into the four corners that you have created for this world. So probably barriers created by majority makes me disabled, but I get labeled because of that ableist attitude. One-size-fits-all approach shows ableism, the attitude carried by able-bodieds. Now, sanism is a very interesting concept coined by Professor Michael Perlin, who says we have lot of misconceptions and prejudices about persons with mental disability. And I would quote few of those characteristics and show to you here itself how legislation has adopted the exact medical model of disability. So they say mental disability is easy to understand, and it can be, by looking at a person, you can make out that a person is mentally disabled. So yesterday where the film was shown, the person with intellectual disability was shown with a specific characteristic. It could not be shown as a normal person. You know, I am standing here, I may have mental disability, but that may not be seen. That's invisible. They are not trustworthy, they are dangerous, violent, they are always incompetent, they are responsible for their own conditions, and they constantly need supervision and control. That's why they are always tied up in asylums. They tend to take wrong decisions, and using derogatory labels against them is socially accepted. So here again, let us think about the term unsoundness of mind, which we use so casually. We call somebody who doesn't understand us, are you mad? Do you think I'm blind? okay? These are all labels showing ableism in language. This is very interesting. Registration Act says, if you go to register a document and if you appear to the registering authority to be an idiot or lunatic, he can reject registering your document. So legislations have made it very simple. I go to the registrar's office, when torn clothes, my hairs are not properly dressed, and then he will look at me, oh look, you look like an idiot or a lunatic to me. I'm, not going to register your document. I mean, that's not how simple it is. So what is a way forward, or are we still having an old wine in a new bottle? So all of you must be aware about the United Nations Convention on Rights of Persons with Disabilities. People with disability had to wait till 2006 to get an independent document recognizing their human rights, whereas UDHR came almost in 1948. That shows that they are never a priority. This is the only and the first international document which says all disabled are equal with persons without disability. UNCRPD compels the state authorities, and India has ratified it in 2007, to say you must abolish that laws which are discriminatory on the basis of disability. So on the contrary, every word in Indian law dealing with discrimination and elimination on the basis of unsoundness of mind must go, since we have ratified it. So as Sir has already spoken about RPWD Act 2016 and 2017, I'm only going to take you to the last 2 points of the 2 instances. Mental Care Health Act speaks about, for the first time, what to consider and what not to consider wherein you are assessing the fact that whether a person is suffering with mental illness. So I will not take you into the factor what to consider, because what not to consider affects us the most. It says don't look into the political, economic, and social status or membership of a person to associate him with the tag of mental illness. Any deviant behavior from moral, social, and cultural and political or religious values and beliefs does not constitute or make him a person with mental illness. Any proof of past treatment or hospitalization shall not by itself be taken as a ground to declare him as a mentally ill person. I'm happy to share the 2017 legislation was relied upon in the common cause judgment, where Article 377 was challenged by, and the judgment was written by Honorable Justice Chandrachud, where he relies on this and say, having deviant sexual orientation doesn't make you mentally ill person, and he has extensively relied on this legislation. And the most important, determination of person's mental illness should not be implied or to be taken that he is a person of unsound mind. So let me bring this point to the forum, that unsoundness of mind is not same as mental illness, which we often end up equating. I would say often the percentage is 99%. We consider unsoundness of mind is it's same as mental illness. Something latest to be shared and something to be reflect upon. Yesterday was a World Mental Health Day, and Deepika Padukone, we all know, one of the actresses who has spoken openly on the forum about her depression issues. And she has been appointed by Union Ministry of Health and Family Welfare as India's first mental health ambassador. Now, what Deepika Padukone has to do with all this in this presentation? Because she is neither a poor or needy section of the society. So how are we concerned in a legal aid conference? This is only to show you how medical model adopted by law is going to create a problem. I'm referring to a Mediation Act of 2023 and trying to think remotely how this is going to affect Deepika Padukone, though she has been appointed as an ambassador of mental health. The matters which are not fit for mediation, see again the obsession with fitness, okay? Schedule 1st of the Mediation Act says any dispute which relates or involves persons with intellectual disability or person with mental illness, their issues cannot be mediated. right? So Deepika Padukone, let me tell you that yes, you are India's first mental health ambassador, but you are unlikely to have a benefit of Mediation Act because the legislation excludes you being a person with mental illness, right? So to move a way forward, I would just say we have to move from letter to spirit. We have to adopt a right-based approach towards persons with disability as a class and not just mental or physical. And we have to, if we have to talk about the role of legal services authorities and the august gathering that I have before, who are the duty bearers to implement the law, I think let us understand that legal aid is a fundamental right of everyone. And disability rights perspective should be our focal point when we are implementing the RPWD Act, the Mental Health Care Act, or Section 12 of the Legal Services Authorities Act. Just to quote what we heard yesterday from Nalsa's anthem, "Ek muthi asman par hamara bhi to hak hai." I think this is a time, let's embrace disability as diversity and not as defect. Thank you.
Thank you, Dr. Rajlakshmi, for such a lucid presentation. The sum and substance of Dr. Rajlakshmi's presentation is that we have to change our mindset. We have to change our perception towards the persons suffering with the disability, including the mental illness, and we have to treat them as human beings. We have to respect them, we have to treat them with compassion. Now, for the purpose of concluding this session, because the time constraint is there, I invite Brother Justice Tarlok Singh Chauhan to conclude this session, sir.
Good afternoon, ladies and gentlemen. Honorable Justice Suryakant, Honorable Justice Vijay Bishnoi on the chair, dignitaries of the dais on the dais. Being the last speaker, it's always advantage as well as the disadvantage. Advantage that I don't have to speak much, but disadvantage to the extent that whatever I thought, whatever I prepared, that has all been short-circuited. So I'm really left with no option but to just dwell on, I think, the challenges and way forward. But before I do so, I really wonder if no one noticed yesterday how this topic was subtly introduced by Honorable Justice Suryakant, when his Lordship said, mental health is a silent issue. Probably this went unnoticed. Why this is a silent issue? Because each of us are very reluctant to talk about this subject. And if we have to cross our hearts and candidly admit, probably each one of us, if not ourselves, but in our families are facing this issue. But we will not talk about it anyway in the public. How do we expect people who are entitled to legal aid speaking about it? So I think we need to accept one thing for sure, that this is the subject matter of an expert who's invested his time, his or her money, time, and acquired these qualifications of dealing with these issues. We can only be a bridge or a conduit between the professional and the person who requires some remedial measures for tackling mental health. We ourselves are not experts. Let's be very clear on that. We could only be kind, courteous, gentle in treating people. Nothing beyond that. So let's not have any misconception that we are experts in the domain. And I would always suggest that it's better we have these conferences where we have the other stakeholders and the government on board. Given the fact that, as the Honorable Justice also just now pointed out, that as against 3 psychiatrists recommended by the WHO, we barely have less than 1 per lakh. So I don't think that is a solution. And unless these professionals are not provided, we are only providing lip service. Maybe you are talking about identification of at the taluka level, which is absent in the state of Assam for the scheme of 2025 or other things. I think all these things become meaningless unless and until we have a proper system in place. After all, it's not that our PLVs are not working or the persons who are entrusted with this task are not working. The question is, the wake-up call is of the government. Having enacted brought in laudable legislations like the Health Care Act or Persons with Disability Act, they need to implement it at the grassroots, at the ground level also. It's not that we take the onus upon ourselves that we are somewhere at fault. Sorry, I think we've done a good share of our job. The onus is on the government. The government must establish healthcare institutions. It is required to deal with these people. We only need to identify. And that probably we are doing. So let's not carry some kind of sense of guilt that we are not doing our jobs. We are doing our jobs. The onus is on the government. Or else, we are not experts on this subject. So, what I would suggest, what I find as, because of the limited time, what are the challenges and what could be the way forward? Is that I've pointed out that there is a acute shortage of psychiatrists. And if at all they are psychiatrists, they are concentrated either at the capital level of the state or the capital of the district or the tehsil headquarters. So it's very difficult getting psychiatrists. In Himachal, when I was dealing with Juvenile Justice Act, for 6 districts, probably we had 1 psychiatrist. So how do we tackle this issue? Then rural mental health infrastructure is absolutely inadequate. And to top it all, budgetary support remains minimal. Then we have a lack of coordination between departments, health, police, judiciary, which requires strengthening. Then the individual problem, which is of persistent stigma, which continues to deter individuals from seeking care and justice. Then the monitoring mechanism under the Mental Health Care Act needs expansion to all institutions. It can't be confined and limited. Every district hospital should have an integrated legal aid and mental health desk. There has to be community-based rehabilitation and awareness campaigns which need to be prioritized. Digital and mobile platforms can extend legal and mental health care access to remote tribal areas, which we are now doing. In fact, mediation, as Honorable Justice Suryakant had pointed out, we are having mediation in some part of Arunachal online. So same way this could be replicated. Then training to paralegal volunteers, especially amongst the tribal communities, would ensure cultural sensitivity, and it will be outreach program. And with continued innovation, we could always make some kind of a national model for integrating legal and mental health systems throughout the country. But till and so long, the government does not cooperate with us, I am of the firm view that much cannot be achieved so far as tackling the menace of mental health is concerned. Thank you, Jayant.
Thank you, Brother Trilok. Now, we have end of the session. We are now on the end of the session. And any suggestion or any question from any stakeholder? Yes, please.
Good evening.
Mike, please.
Yes.
Sir, I am Anand Sen from High Court of Jharkhand. So mental health issue, it has a wider ramification, especially from the state and the district which I come from. It is not only the behavioral aspect which a person goes through and the family goes through. First, they are outcasted. We brand them, as Pagal has said, they outcasted. Legal Services Authority, we come up, we take them to the hospital and get them treated. What happens after that? Are the family well sensitized to take them back to their society? Answer is no. 1 out of the 100 also not. Then another problem in our place is you link it with witchcraft. These people, the community, to grab their land, especially the women's, they brand them as a witch and they burn them to death to take this. This aspect has to be taken care of by Legal Services Authority, and this is a menace, I'm telling you. And we have to take it in a very urgently. This is only what I have to say.
Yes, brother, you have rightly pointed out that now all the stakeholders upon whom some responsibility has been casted by the Act of 2016 and 17 will have to play its role, and ultimately we have to create an atmosphere where the society can change the mindset regarding the mental illness. Sir, please.
Dr. Rajlakshmi, maybe you being one of the subject expert, but at the same time not a part of the system about which I am asking this question, can you please in few lines highlight that what better role NALSA can play with respect to providing the counseling or legal aid in the cases of mental health, and how this subject on the platform of NALSA can be further really taken care?
Yes, thank you, sir. I'm grateful for your question. Yeah, I hope I'm audible. Yes. So, sir, when this session was decided, the concept note was circulated, and I believe I have nothing new to say, but the concept note itself has suggestions, and it says, first, let us bring awareness and let us bring trainings to those who can implement the provisions with a right-based perspective. So I would say it will be a 3 or 4 part process. Probably let us first understand, I wanted to, since you asked the question, I'm happy to share. Discrimination is prohibited by law, but if the discrimination is unintentional, which often happens with all of us, is more dangerous. Because if I do not know that I'm really discriminating, I may never accept the fact. And if I do not accept the fact, there is no awareness. And if there is no awareness, probably there is no scope for change in my attitude or behavior. So I believe all of us will agree that we do have legislations like 2016 and 17 because we have ratified the United Nations Convention. So I believe the legislations are there. Now we just have to look at it with a right perspective. Just to draw up analogy, we always say sex and gender are two different things. Sex is biological and gender is social. Similarly, impairment is medical connotation and disability is a social construct. So if every one of us, and I keep on saying every one of us because I'm not shrugging off any responsibility as a citizen to reach out to people and develop that perspective. If every one of us in our best possible manner, if gives even once, if a thought comes to your mind when you go out of this hall and then take up your responsibilities, that let us relook at the situation with a rights-based perspective. I believe, sir, the NALSA, SALSA and DALSA will be, India's DALSA, NALSA and SALSA will be the most effective machinery to implement the rights of everyone and overcome discrimination. Thank you.
Good afternoon, Your Lordships.
Sorry.
Hello. Good afternoon, Your Lordships. I am Shankari Das, LRN Secretary from Government of Tripura. Madam, I have 2 points to make. One is, you referred Registration Act.
Yes.
And according to you, this is discriminatory. But in my view, registration is denied to the lunatic and the person with unsound mind for the benefit of that person, to protect the interest of that person. Unless it is denied, then he will be affected. So I don't understand how it appears to be discriminatory to you. It is my first point. Okay. Second point, you also pointed out that mentally custody is denied to the mentally ill guardian. Actually, madam, good or bad, which act is good, which act is bad, these are two relative terms. It was settled by Bertrand Russell, who was the great mathematician and philosopher. He said, the consequence of any act, if it is good, then it is a good act. If the consequence of any act is bad, then it is a bad act. Now, if custody is given to a mentally ill guardian, then the future of the child will be in danger. So I think we should not look at this as discriminatory. It is for the benefit of the child, the custody should be denied. It is my view.
Yes. Ma'am, would you like me to just clarify? Yeah. Yes. Coming to the first point, I would draw from what the Lordship said just now. Whether somebody is suffering from mental illness or not, it's a job of an expert. If we read the provisions of a registration act, it allows the executive body who is appointed as a registrar to look at the person and from his appearance decide whether he is lunatic or mentally disabled. So I'm not against the point of protecting them, but I'm certainly against the fact that we cannot look at a person and decide whether he is mentally ill or not. You have to refer probably the matter to medical review boards under the Mental Health Care Act, right? And then get it decided. I mean, sitting here and looking at a person and labeling him as mentally ill and deny his rights under the Registration Act, that's certainly not what I meant to say is going contrary to him. Now, coming to the custody issue, I would like to answer that question. That illustration was given by me only to make a point that impairment, or rather let's say affected physical or mental capacity, is time specific and also task specific. You will have psychologists to support the fact or psychiatrists to support the fact that a person who has mental illness does not mean necessarily that he cannot do anything at all. However, with support, the person can do many things, and that is the reason why, as sir also again rightly said, it is the responsibility of the state to put support, to give support, and that's what precisely, as sir also pointed out, are the duties under the Mental Health Care Act. So I'm just putting forth a point that I understand that yes, the child security and welfare is a paramount consideration, but at the same time, merely because a person has mental illness, that cannot be taken as a ground to say that he is incapable.
Hello.
Thank you, ma'am. Yes. Yes,
I am taking the privilege. I am Malika Ratna, District and Session Judge, Nalbari, Assam.
Yes.
I would like to just taking the privilege because Analsa is there. Some mentally ill ladies are being sometimes identified in the roads and all. There are some small NGOs in a place, in Assam where I work. I have visited several legal awareness camps in those NGOs. But main problem is that childline NGOs are very less, Lordships. So I would just request the NALSA, if there is some fund that can be provided to those NGOs for looking after those mentally ill ladies or whoever person is detected, those are facing lots of problems. I would like to put forward, it is just a kind of suggestion, or because NALSA is here, I am taking the privilege of putting forward such a suggestion before your Lordship.
Yeah, that's right. You are saying that if the NGOs who are working in this field, some funds should be provided to them.
Yes,
but as pointed out by Brother Trilok Singh Chauhan, that it is the primary duty of the state. If they found that the NGOs is working in this field and they are doing some work, then it is for the state to think over it, that to provide them some fund and all. In fact, NALSA, yes, NALSA can also, but NALSA can act through the DLSAs or the State Legal Services Authority and not directly with the NGOs. So, yes, you are having a good point, and it is for all the stakeholders to ask the government to provide some assistance to those NGOs who are working in this field.
Thank you.
Thank you. So now, I think so it's the most interactive session out of all the sessions, and therefore the most useful session. Now with this, looking to the time constraint, we are concluding the session. All of, I thank you, all of those persons for having this patience hearing about this session. And we have some useful suggestions from the experts as well as Brother Chauhan. And we should take a resolve that now, from now onwards, will discharge the duties towards the persons who are suffering from mental health or mental illness with compassion and change our mindset regarding them. Thank you very much.
We are deeply grateful to each of our panelists for their invaluable insights. We indeed had a great session, replete with learnings. Ladies and gentlemen, this brings us to a close of the sessions, which were of immense importance, and I'm sure the entire fraternity would be benefited by the views shared in each of the sessions so profoundly. Would like to express my sincere gratitude to the panelists across all sessions for bringing out the best on the given topics. Ladies and gentlemen, we would now just take a moment to do up the stage, and then we would proceed with the valedictory session. For your information, you can download the photographs of the events from the link that will be displayed on the screen. You can either use the scanner or take a picture of the link. Thank you. Ladies and gentlemen, we are honored to have with us Honorable Mr. Justice Vikram Nath, Judge, Supreme Court of India and Chairman, Supreme Court Legal Services Committee. I'd request you, sir, to kindly come forward and take your seat on the dais. His Lordship is being escorted by Shri Bishwajit Chakraborty, LR and Secretary to the Government of Assam. We are also delighted to have with us Honorable Mr. Justice M. Sundresh, Judge, Supreme Court of India. His Lordship is being escorted to the dais by Shri Piyush Protim Boiragi, District and Session Judge cum Chairman, DLSA, West Karbi Anglong. May I now request Dr. Ajit Atri, Director, NLSA, to kindly escort Honorable Mr. Justice Ujjwal Bhuiya, Judge, Supreme Court of India, to the dais. Namaskar. Ladies and gentlemen, on behalf of the Assam State Legal Services Authority and the Guwahati High Court, the High Court of Assam, Nagaland, Mizoram and Arunachal Pradesh, I would like to extend a warm welcome to you all to the valedictory session of the National Legal Services Authority East Zone Regional Conference of 7 northeastern states and Sikkim, Bihar, West Bengal, Jharkhand and Odisha. We would now like to felicitate our esteemed guests on the dais, starting with Honorable Mr. Justice Vikram Nath, Judge, Supreme Court of India and Chairman, Supreme Court Legal Services Committee. I would request Honorable Mr. Justice Ashutosh Kumar, Chief Justice, Guwahati High Court, to kindly do the honors. Thank you. May I now request you, sir, to kindly felicitate Honorable Mr. Justice M.M. Sundresh, Judge, Supreme Court of India. Thank you. I would yet again request you, sir, to kindly felicitate Honorable Mr. Justice Ujjwal Bhuiyan, Judge, Supreme Court of India. Thank you, sir. I'd request you to kindly take your seat. Ladies and gentlemen, Honorable Mr. Justice Ujjwal Bhuiyan, son of the soil, was appointed as additional judge of Guwahati High Court in 2011 and confirmed in 2013. Later, his lordship was appointed as the Chief Justice of High Court for the state of Telangana in the year 2022. In the year 2023, his lordship was elevated as a judge of the Supreme Court of India. I now request Honorable Mr. Justice Ujjwal Bhuiyan, Judge, Supreme Court of India, to kindly share a few words with this august gathering.
Honorable Justice Surya Kant, Judge, Supreme Court of India and Executive Chairman of NALSA, Justice Vikram Nath, Justice M.M. Sundresh, Justice Bishnoi, Judges of the Supreme Court of India, the Chief Justices of different High Courts participating in this conference, Honorable Judges of Guwahati High Court and all other High Courts again participating in this conference, Chief Secretary, Government of Assam and the other state government officials, judicial officers who are present here, learned advocates, distinguished ladies and gentlemen. A very good afternoon to all of you. It is with a profound sense of happiness and fulfillment that I stand before you this afternoon at the conclusion of a truly illuminating conference. The 5 sessions which started from yesterday morning in the conference have been very carefully curated to deal with issues which are of special relevance, particularly to this region. We had a technical session on prevention of child marriage and protection of child rights. Then this was followed by the menace of narcotic drugs and psychotropic substances. And we had the last session yesterday pertaining to rights of tribal population. This morning we had issues relating to the tea garden population, which is so very contemporary relevant to this region, and the last session on mental health and legal aid. I'm sure all of you who have gathered here would be carrying back valuable lessons from the inputs that we have received from the resource persons and the learned judges all through these 5 sessions. Friends, this legal services movement or the legal aid movement as we see in this country has now transitioned from the perspective of only legal aid to legal services. The field has become wider. But we need to remember that even when it comes to legal aid, it was not a done thing or an accepted thing from the very beginning. This has also evolved over the years. In fact, judicial attitude towards legal aid was very conservative at the initial stage. I remember there is a case, Tara Singh versus State of Punjab. This is way back in 1951, when the Supreme Court held that right to be represented by a lawyer was a privilege given to an accused, and that it was his duty to ask for a legal assistance if he wanted one, or if his family members should make a request that he should be provided legal assistance. Things have certainly changed after that. We had the 14th Law Commission headed by the then Attorney General, M.C. Setalwad. Then we had the Justice P.N. Bhagwati report in 1971, and then Justice Krishna Iyer report in 1973, which said that the legal system should become an effective tool in helping secure the ends of justice. It emphasized on the need for an effective and widespread legal aid system in the country. Then in 1976, we had the 42nd Amendment. Though this 42nd Amendment is known for many other things, but one of the salutary contributions of the 42nd Amendment is the insertion of Article 39A in the Constitution, which speaks about providing equal justice and free legal aid, highlighting that justice should not be denied to any citizen because of economic or other disabilities. Then, of course, post-emergency, by interpreting Article 21 in the light of Article 39A, Supreme Court delivered one landmark judgment after the other, particularly in the 70s and in the 80s. In Madhab Hoskote's case versus State of Maharashtra, Supreme Court held that right to free legal aid is a guaranteed fundamental right under Article 21. Then in Sukhdas versus State of Arunachal Pradesh, Supreme Court held that a trial without offering legal aid to an indigent accused at the expense of the state will be vitiated and conviction will be set aside. We had a host of judgments from Husainara Khatun to others which said that right of an accused to a speedy trial, to a fair trial, these are all inbuilt or traceable to Article 21. And the concept of legal aid continued to be expanded thereafter. In Raju Ramakant versus State of MP, this is a 2012 judgment, Supreme Court noted that legal aid is to be provided at all stages, not merely at the trial stage. And in that Ajmal Kasab case, Ajmal Kasab versus State of Maharashtra, Supreme Court observed that it is the duty of the magistrate to make the accused aware of his right to be defended by a legal practitioner of his choice. And if he has no means to engage a lawyer of his choice, the state is to provide one. The impact of these judgments was so profound that it compelled the Parliament to enact the Legal Services Authorities Act 1987. And from then onwards, we can see the gradual transition from legal aid to legal services. The objective of the Act is to constitute legal services authorities for providing free and competent legal services to the weaker sections of the society, so as to ensure that nobody is denied access to justice by reason of economic and other disabilities. The criteria for extending legal aid or legal services or the persons who are entitled to receive legal services are mentioned in section 12. So there is a metamorphosis from legal aid to legal services, and from an indigent accused to a host of persons who are entitled to free and competent legal services under section 12. Friends, the legal services institutions have performed a crucial and credible role in providing fair and equal access to justice to those who are mostly excluded from our legal system: the homeless, the jobless, victims of domestic violence, and many others covered by section 12. Millions of vulnerable citizens have been benefited from fair and equal access to justice provided by the legal services institutions. As society is recognized as a matured one in the way it cares and acknowledges the rights of the marginalized and the weakest members of the society. We have for long been a society of hierarchies with concentration of wealth and privileges at the top for a few. We must change this. For this, the Constitution is our guide. The legal services movements can play a significant role in this transformation. We must all remember that justice cannot be and should never be an accidental privilege. It is, and it shall always be, a guaranteed right. Providing of legal aid and legal services to the needy and those who are in distress is a divine duty, and all of us must feel blessed to have got an opportunity to discharge our duty and be a part of such a noble cause. I must congratulate the Assam State Legal Services Authority, the Guwahati High Court, and the Government of Assam for organizing this two-day conference here at Guwahati so successfully. The hospitality extended to all of us has been outstanding, par excellence. Thank you very much for this. The way the conference has been organized and the hospitality extended to one and all deserves a special mention. I am sure all the participants will go back to their respective stations, enriched by the rich deliberations and the camaraderie developed over the last couple of days here. My request to the Assam State Legal Service Authorities and the other state legal service authorities is that we must follow up on the topics that we chose to deliberate upon the last 2 days. There are other topics also of seminal importance, as Justice Ananda Sen has said. The issue of witch hunting is so very prevalent in this part of the country, Jharkhand, Chhattisgarh, and so many, West Bengal, Assam. These are also issues which needs to be tackled and discussed and debated. Friends, we now come to close of this conference. May the fond memories that you carry from here linger on with you for a long, long time. Thank you very much, and God bless.
Thank you, sir. Ladies and gentlemen, Honorable Mr. Justice M.M. Sundresh was appointed as Additional Judge of the Madras High Court in 2009. His Lordship also served as President of the Tamil Nadu State Judicial Academy before being elevated to the Supreme Court of India in 2021. His Lordship meticulously authored significant judgments on juvenile justice, regulatory jurisdiction, the retrospective application of juvenile laws, and criminal procedural protections. May I now request Honorable Mr. Justice M.M. Sundresh, Judge, Supreme Court of India, to kindly address this distinguished gathering.
Thank you. Honorable Justice Surikant, Justice Vikram Nath, Justice Ujjal Bhuyan, Chief Justice Asutosh, other Chief Justices, distinguished invitees, ladies and gentlemen, a very good afternoon to all of you. Valedictory function is like a prize distribution after a match. So the speakers, they don't participate, but they give a nice review. It is like the winners after the match would be happy, then they will go home with a happy mood. The losers also would be happy that match has ended. So both ways it's a good occasion to speak. There are 5 topics of discussion over the last 2 days. The first topic is, as my brother Ujjal Bayan has said, on the prevention of child marriage and protection of child rights. Both complement each other. We have the 3rd largest child marriages in the world, with the concentration of 5 states. In his book, Prophet Khalil Gibran makes an interesting statement about children. When a question was asked, he said, children are not born from you, but through you. They are sons and daughters of life's longing for itself. Now, when we talk about child marriage, it's a case of changing a child into a woman. There are multiple reasons which obviously you would have all discussed. It may be cultural, it may be social, it may be economical, or it may be even be religious. That's where Legal Service Authority has rightly entered into this arena. As a single stakeholder cannot deal with this problem. The problems are indeed multifold. I distinctly remember to have dealt with an interesting case where the girl on her own came to the hospital for delivering a child. She was from a tribal community. The custom there was that they would get married. The girl will be about 16, the boy will be about 17. Now, at the time of registration of the date of birth, the doctor entered into and informed the police, and the police came and arrested her husband. Now, she is being punished twice. I think we have to move forward to understand the functioning of the society and try to redeem it. We would only be causing grave injustice to the child who gets married and thereafter made to suffer eternally. But also the children born out of the marriage would become inheritors of poverty. This is something which is really disturbing. Now, coming to the second topic, which deals with psychotropic substance and narcotics. My colleagues would know, this is, almost every day we deal with these cases in Supreme Court. Which means these cases are on the rise. Whether it is homemade drugs or drug from across the border. The problem does persist but also escalates. Only difference is the usage of drug and substance will be different from state to state. Here again, the victims are children, adolescents, rather than young men and middle-aged persons. Even among young men, you will see that it's a continuation from the adolescent age. I do not want to discuss much about this except by saying that perhaps we need to have a different look about this issue. In my little experience, I have seen that the real perpetrator, maybe the main person behind, always escapes. Somewhere the focus is missing. We need to identify the source and try to remove the base. what we are doing is to take care of the person who involved in distribution. They are nothing but paid employees. The system continues, affecting the entire youth force. Therefore, a different approach probably is a requirement of the day. The third is with respect to welfare of the tribes and with specific reference to the scheme. It was consciously thought after the independence to leave them alone. When you talk about tribes, we talk about different communities. Some of them would be on their way to merge with development, with the modern world, while the others would prefer to stay. But the common factor here is the exploitation. We have moneylenders, land sharks. There is an interesting statement made way back in 1854 by the Indian chief of the Seattle in Washington. I'm talking about the Red Indians, the native Indians you can call. In his speech he has said, how can sky and the land be bought or sold? The breezy air and the sprinkling water, they have their own lives. They do not belong to anybody. Rivers are our sisters, our brothers. They fed our children. They helped our canoes. Teach your children to treat them like brothers. I think this is the problem. When we understand the world through our own experience and materialism, it does cause serious damage to others who believe in nature. The scheme goes a long way in creating committees, adopting welfare measures, giving better facilities, education. What I would only say is that a multi-pronged approach is required with an element of sensitivity. The fourth topic is on the sufferings of the tea plantation workers. Here again, the sufferers are women who constitute 50% of the workforce and the children born to them. The fundamental question is here, pardon me if I am saying this, is that what is the importance of tea? The colonial legacy has been brought into this. I think this is the single most destructive step taken by the British from the environmental ecological point of view to affecting millions of people. Obviously, they are interconnected. Tea is a beverage, I don't think it's a food. Maybe we have to seriously think of looking for alternatives. That I believe that's the best way. We have to do a lot of sacrifice. I'm sorry to say this, tea gives us a lot of refreshment. How much of the tea plantation plant we use? You use fertilizers, you water, then you suffer, you are completely destroyed, or in the process of destroying the flora and fauna the people live under. Exploit them, the exploitation continues. We do introduce schemes. Can we replace pristine forests, grasslands, native the trees? I think it's a very unfortunate situation. I think probably we are the creator of the problem. And the last one is on the mental health. So I had the pleasure of listening to some of the questions put and then the wonderful answers given by the speaker. In Macbeth, Shakespeare beautifully says, Macbeth himself answers this, he says, I have not committed the murder. It's a madness that has committed the murder. And therefore, Macbeth, that is myself, is a victim. I only look at it, once again, we say that we have more criminal cases than civil cases in Supreme Court. There is, behind most of the crimes, there is a victim. We don't look at it from that perspective, because character is something which is formed, for which even the offender may not have a role to play. Mental health is something which we have to understand from a different perspective, because physical health, what we think is that we see our physical condition, therefore we take treatment, but we never bother about the mental health. All of us have our own degree of mental disability or mental problem. That's the truth. Despite being judges, we do have a problem, because when you deal with issues, because that's the reason why one of the reasons I find is one of the reasons why the judgments do vary. Maybe the thinking process, whatever we may call. Here again, I find that infrastructure is found wanting. If you take the cases of persons who were in need, the psychiatrists and psychologists we have, not even it will cater to even 5%. Identifying the serious cases and taking care of them would show how mature the society is. Now, with these few words, I once again congratulate the organizers for having this program. Thank you very much for giving this opportunity.
Thank you, sir. Ladies and gentlemen, Honorable Mr. Justice Vikram Nath was appointed as a judge of the Allahabad High Court in 2006, later serving as the Chief Justice of the Gujarat High Court in 2019. His lordship was elevated to the Supreme Court of India in 2021. Renowned for his progressive outlook and judicial innovation, his lordship became the first Chief Justice in India to live stream court proceedings on YouTube, promoting transparency and public access to justice. He has contributed to several legal publications and taken a proactive role in addressing issues of public concern, notably interventions during the COVID-19 pandemic, exemplifying his dedication to judicial accountability and human rights. I would now request Honorable Mr. Justice Vikram Nath, Judge, Supreme Court of India and Chairman, Supreme Court Legal Services Committee, to kindly deliver his valuable speech.
A very warm good afternoon to everyone present in this beautiful auditorium. Honorable Mr. Justice Suryakant, Judge, Supreme Court of India, Chairman, National Legal Services Authority, my esteemed colleagues, Justice Sundresh, Justice Bhuyan, and Justice Bishnoi, Honorable Chief Justice of the host High Court, that is Guwahati High Court, and other participating states, Executive Chairmen of State Legal Services Authorities of the participating states, Honorable Judges, present and former, gracious spouses, judicial officers of the judiciary of the state of Assam, and government servants present here from the executive of the state of Assam. At the outset, let me tell you an honest confession that valedictory is the most boring part of the entire conference. But it has to be there. Given a chance, someday I will eliminate valedictory sessions and relieve all the participants early in time so that they can have either another working session or enjoy their time otherwise. But since I am here, so I have to perform my pious duty of delivering this valedictory address. It is a privilege to stand before this august gathering today afternoon and deliver the valedictory address at the close of this inspiring two-day program organized by the Assam State Legal Services Authority and the Guwahati High Court. Over these sessions, we have not just spoken of laws and policies, but of people, of lives, and of real struggles and hopes. That, in the end, is what makes this dialogue meaningful. It tells us that justice is most importantly about human stories. Nelson Mandela famously said, "There can be no keener revelation of a society's soul than the way in which it treats its children." We began this conference by speaking of the children of our nation. When we talk about preventing child marriage and protecting child rights, we are not merely addressing legal issues, but safeguarding the very future of our society. Marrying of our children is not a tradition, it is injustice. Every child deserves far more than food and shelter. They deserve an environment where they can dream freely. Child marriage silences voices before they have even found their strength. And the price of that silence is not paid by the child alone. It is borne by the entire community and by the nation itself. Our Constitution recognizes this truth. The right to life under Article 21 means a life of dignity and development. Article 21A guarantees education because without education, equality and freedom are illusions. Article 39F directs us to protect children from exploitation so that they may grow up with security and dignity. Laws like the Prohibition of Child Marriage Act 2006, Juvenile Justice, Care and Protection of Children Act 2015, Protection of Children from Sexual Offences Act 2012 are some of the tools at our disposal, but tools only work if we use them with resolve. Real change comes when parents, communities, and institutions decide that every child deserves a life free from fear or burden, a life of opportunity and hope. From there, we turn to one of the most pressing challenges of our time, the growing crisis of drug abuse. In India, as around the world, drug abuse is a deep social wound that cuts across every layer of our community. Behind the numbers are real lives. Young people with immense promise who lose their way. Young people with immense promise. Families who suffer in silence, and communities that carry the burden of pain and stigma. We must remember that every case is a story of struggle and suffering. Our responsibility as a society is not merely to enforce the law, but to extend empathy. We must work to heal and not to punish by raising awareness, offering treatment and rehabilitation, and building strong networks of care and support. Only through understanding and compassion can we help our youth choose recovery over addiction and life over despair. The focus then shifted to our tribal communities, who are the guardians of culture and of nature, but also equal citizens whose rights our Constitution compels us to protect. Theirs is a fight for justice, for land, for identity, and for dignity. True progress means coexistence, where development uplifts without erasure and heritage thrives alongside growth. The Samvad scheme is a step in that direction. It serves to remind that real change begins by listening, not imposing, and by walking with communities, not ahead of them. Only then we can strive for a future where every voice counts and no tradition is left behind. Yesterday, we also turned our attention to the tea garden workers whose labor has brought warmth and comfort to countless homes across the country and around the world, but whose own lives remain marked by hardship. Many of us may never look up at a cup of tea quite the same way again. The labor of thousands who often live in difficult conditions, deprived of health care, fair wages, and educational opportunities for their children, goes into every cup. Justice for them is thus a promise for tomorrow and an assurance of fair wages, dignity, and rights today. We must ensure that the children inherit lives of hope and not hardship. One of the most powerful sessions was on mental health and legal aid. This is an issue often relegated to the shadows, yet one that belongs at the very center of our attention. In the wake of World Mental Health Day on October 10th, this discussion could not have been more timely. In the judgment of Sukhdev Saha vs. State of Andhra Pradesh, 2025, it was affirmed that mental health is a constitutional right under Article 21. Education is meant to liberate, not burden the learner. When institutions neglect student well-being, they are going against our constitutional values. The loss of even one young life to neglect or pressure is a collective failure. This judgment is but the beginning of our duty to ensure every student can live with a healthy mind and a hopeful future. A person suffering from mental illness is often the most vulnerable, yet the least protected. The law must open its doors to those who are strong enough to knock and reach out to those who cannot. We must also emphasize the need for fostering communities that take responsibility for each other's well-being so that mental health concerns are identified sooner and care becomes more timely, compassionate, and effective. What strikes me most as I reflect on these sessions is how interconnected these themes are. Whether it is children, tribal communities, tea workers, or those struggling with addiction or mental illness, the thread running through all of it is vulnerability. And it is in the treatment of the vulnerable that the true measure of justice is found. Dr. Ambedkar reminds us that Constitution is not a mere lawyer's document. It is a vehicle of life, and its spirit is always the spirit of the age. That spirit was very much alive in this hall for the past 2 days. Every session, every speaker, every question carried with it the reminder that the law must breathe, it must evolve, and it must serve the people as they are today, not as they were yesterday, nor only as we imagine them tomorrow. Gatherings like this are not just academic exercises, they are vital conversations. They bring together judges, lawyers, administrators, scholars, activists, and citizens in one space. And in that dialogue, the law becomes a shared commitment to fairness, equality, and dignity. Friends, these 2 days have been a reminder of why we do what we do, why we keep striving, why we keep questioning, and why we keep believing that no dream of justice is too distant. I congratulate the organizers, the speakers, and each one of you who participated with such sincerity. May we carry forward the knowledge, compassion, and commitment we have gained here. Thank you. Jai Hind.
Thank you, sir. I would now request Shri Bharat Parashar, Member Secretary, NALSA, to kindly deliver the vote of thanks.
Namaskar, a very good afternoon to everyone. It is indeed my profound honor and privilege on behalf of the National Legal Services Authority to extend this vote of thanks as we conclude the East Zone Regional Conference hosted with such warmth, grace, and hospitality here in the vibrant and culturally rich state of Assam. Over the past 2 days, this gathering has not only witnessed meaningful deliberations but has also exemplified the spirit of collaboration, dedication, and shared purpose that defines the mission of NALSA, access to justice for all. As I speak, I am overwhelmed with a profound sense of gratitude and appreciation towards so many people. At the very outset, I would like to express my deepest respect and gratitude to Honorable Mr. Justice Suryakant, Judge Supreme Court of India and Executive Chairman NALSA. The insightful guidance of Sir and his visionary leadership and unwavering commitment towards strengthening legal services across the country continue to inspire every limb of this fraternity who work tirelessly. Sir's presence at this conference lends both dignity and encouragement to our collective efforts. I also extend gratitude to Honorable Mr. Justice Vikram Nath Judge Supreme Court of India and Chairman Supreme Court Legal Services Committee. Sir, your experience and vision of a welfare legal aid system strengthen our resolve to develop effective legal frameworks, ensuring that justice reaches the most marginalized communities efficiently and empathetically. I further extend my sincere regards to Honorable Mr. Justice M.M. Sundresh, Judge Supreme Court of India. Sir, your gracious presence has added immense value and significance to this conference. Also, sir, your consistent and constant support to NALSA in its initiatives has always inspired and encouraged us. Sir, your insightful perspective and guidance has really greatly enriched the deliberations of this conference. It is my privilege to also acknowledge the esteemed presence of honorable judges of the Supreme Court during this conference, Honorable Mr. Justice Dipankar Datta, Honorable Mr. Justice Prashant Kumar Mishra, Honorable Mr. Justice Ujjal Bhuya, Honorable Mr. Justice Sandeep Mehta, Honorable Mr. Justice N. Koteshwar Singh, Honorable Mr. Justice Joymala Bagchi, and Honorable Mr. Justice Vijay Bishnoi. Your engagement and participation have significantly enriched the discussions and deliberations over the course of this conference. I also place on record my profound gratitude to Honorable Mr. Justice Ashutosh Kumar, Chief Justice of Guwahati High Court and Patron Chief of the SLSAs of Assam, Nagaland, Mizoram, and Arunachal Pradesh. Sir, your warm hospitality and meticulous involvement in hosting this East Zone Regional Conference have made this gathering an ideal platform for meaningful exchange. I would like to extend my sincere gratitude to Honorable Mr. Justice Vishwanath Somadar, Chief Justice High Court of Sikkim, Honorable Mr. Justice M.S. Shri Ramachandra Rao, Chief Justice High Court of Tripura, Honorable Mr. Justice Harish Tandon, Chief Justice Odisha High Court, Honorable Mr. Justice Trilok Singh Chauhan, Chief Justice High Court of Jharkhand, Honorable Mr. Justice M. Sundar, Chief Justice High Court of Manipur, Honorable Mr. Justice P.B. Bajantri, Chief Justice Patna High Court, Honorable Mr. Justice Somen Sen, Chief Justice High Court of Meghalaya, and Honorable Mr. Justice Sujoy Paul, Chief Justice Calcutta High Court, for their esteemed presence during the conference. Lordships, your thoughtful participation has provided invaluable perspectives on region-specific issues, interlinking state-level experiences with national frameworks for legal aid. I would also like to acknowledge with gratitude Honorable Mr. Justice Michael Jothan Khuma, Judge Guwahati High Court and Executive Chairman Assam SLSA, for his tireless efforts in planning, coordinating, and executing this conference. Sir, your dedication to weave an elaborate dialogue between different agencies to enhance legal aid in the Northeast and ensuring that the conference was seamlessly organized is deeply appreciated. I also express my gratitude to the honorable judges of the Guwahati High Court, as well as the honorable judges from the participating high courts, whose presence added depth, insight, and credibility to our deliberations. On behalf of NALSA, I also extend sincere regards to Dr. Himanta Biswa Sharma, Honorable Chief Minister of Assam, for gracing this occasion with his benign presence and addressing the audience in such a beautiful and engaging manner. I also thank the Government of Assam and officers of the Executive Wing for their logistical and administrative support, which has ensured that this regional conference becomes a resounding success. I also extend my gratitude to Shri Arjun Ram Meghwal, Honorable Minister of State for Law and Justice, Independent Charge, for his valuable insights and guidance. I also thank him for his unflagging support in all the legal aid initiatives of NALSA at all critical junctures. I also extend my heartfelt felicitation to Mr. R. Kota, Chief Secretary, Assam, and Mr. Rupin Sharma, DGP Nagaland, and all the other resource persons who were part of various sessions. Their invaluable insights, knowledge, and contributions have really enriched these deliberations. I also extend my regards to learned Member Secretary of Assam State Legal Services Authority, Shri Debashish Bhattacharjee, and his entire team for so meticulously organizing this regional conference. This conference is a testament to their behind-the-scene hard work, meticulous coordination, and dedication. Despite the tremendous time constraints and grueling pace and intensity of work all around for organizing this event, they continued to work passionately without complaints, and for that they deserve special accolades. I would also like to place on record my sincere appreciation to the learned district and session judges, learned member secretaries of participating states, the senior judicial officers, and officers of the legal services institutions for their presence and participation in this event. Last but not the least, a special thanks to all the unnamed volunteers who have selflessly offered their time and energy in ensuring the seamless execution of this event. Their enthusiasm, hard work, and dedication have not gone unnoticed, and we are incredibly grateful for their contributions. Over the last 2 days, this conference has served as an invaluable platform for dialogue, reflection, and collaboration on issues of critical significance common to the region. Given the extensive nature of these challenges, it is pertinent that legal services institutions should devise and innovate practices that prioritize the regional issues. Such innovations should be tailored to the region's diverse socio-economic and cultural context and should integrate flexible, solution-oriented strategies. By doing so, legal services institutions can ensure that legal aid is not only accessible, but also meaningful, impactful, and responsive to the specific needs of the community they serve. Friends, as we leave Guwahati, let us carry forward the spirit of this conference, a spirit of collaboration, action, and innovation to strengthen legal aid delivery, address social and legal vulnerabilities, and build a more responsive system. I would like to add here that alone, a stalk of bamboo may be fragile, but together they form an unshakable grove. Similarly, every state in a region, when they work together, can overcome common challenges they face. As I reflect on the discussions, debates, and insights shared over these 2 days, I am reminded of the profound words of Rabindranath Tagore. I slept and dreamt that life was joy. I awoke and saw that life was service. I acted and behold, service was joy. Thank you once again for your invaluable contributions, guidance, and presence. May the insights gained here translate into meaningful action, and may our shared commitment turn these insights into meaningful change for communities in need. Thank you. Jai Hind.
Thank you, sir. I would now request all present to kindly rise for the national anthem. Thank you. Ladies and gentlemen, with this we have come to a close of this grand and impactful event, an initiative that has undoubtedly broadened perspectives and enriched the knowledge of all the esteemed dignitaries and participants present. Thank you. I'd request all present to kindly proceed for lunch. Honorable state dignitaries, honorable judges, their spouses, senior government officials and resource persons would proceed to hall number 2. Registry officials would escort them. The participants and delegates may proceed towards my left to hall number 1. Thank you all once again.